Good afternoon, Webb County Court of Law 2. I'm Victor Villarreal, judge of your Webb County Court of Law 2. This is the civil probate and guardianship docket for Tuesday, August 18, 2006. The time is now 2:01. Court is now in session. Assisting us today is court coordinator Gloria Noriega, probate court investigator Liza Rodriguez, interpreter Ubaldo Cuellar. Video conference co-hosts this afternoon include Mr. Lopez, Ms. Ramos, Ms. Cuellar, Mr. Hernandez, Ms. Rivera. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum. Wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person and then those online as measured by your login times. Ms. Noriega.
Yes, I don't see Council Jonathan Garcia Davalos. We're gonna go to Council Eduardo Romero, page 4, number 8.
Maverick Fitness LLC versus Visual Graphic A2 LLC, cause number 2025 CVD 75L2. Court marks Mr. Romero present in person. Mr. Chu, are you present?
Good afternoon, Judge. Nathan Chu present.
Good afternoon, counsel. Court marks you present. You're participating by video conference. Any other parties, witnesses, or anybody else that is here on this case? So noted. Mr. Romero, Mr. Chu?
Yes, Your Honor. Mr. Chu and I filed a joint motion for continuance, for an agreed motion for continuance. We had agreed to attempt to settle the case through mediation with Justice Contreras. However, our schedules have not matched to be able to attend the mediation, so we're respectfully requesting a reset, Your Honor.
Mr. Chu?
That is correct, Your Honor.
Ms. Noriega, give us a setting in within 45 days.
My next available, Your Honor, is October 8th at 9 a.m.
Any objections, Mr. Romero?
No, Your Honor.
Mr. Chu?
No, Judge.
Give me 1 second.
Yes, Your Honor.
Oh, I see that. The court has signed that motion for continuance and tendering the original to the clerk's office. Anything else on this case, Mr. Romero?
No, Your Honor.
Mr. Chu?
No, Judge.
Any other cases for Mr. Chu?
For Mr. Chu, further down the line.
All right, go ahead.
Next is page 5, number 13.
This is Rogelio Fabian Gonzalez Mercado versus Roella Jr., cause number 2026 CVD 48L2. Court marks Mr. Romero present in person. Rogelio Mercado Roquevela, any parties present? Please step forward. Speak into the microphone and tell the court, are you Rogelio Fabian Gonzalez Mercado?
Yes, I am Rogelio Fabian Gonzalez Mercado.
Welcome to court, sir. The court marks you present in person. Mr. Mercado, do you have a lawyer?
No, sir.
Will you be going forward without a lawyer?
Yes, sir.
Court marks you self-represented. Ms. Noriega, does the court have Mr. Mercado's email address?
No, Your Honor.
Mr. Mercado, what is an email address for you?
My name, Rogelio, my initials, FGM, #1, .gmail.com.
One more time in case we missed it.
my name Rogelio, my initials FGM, number 1, gmail.com.
Got it.
All right, be on the lookout in your emails. If the court needs to send you any notices or any information, it'll go to that email address. Similarly, if Mr. Romero, on behalf of his client, needs to send you any information or request notices, it'll go to that email address. Mr. Romero, have you had an opportunity to talk to and confer with Mr. Mercado?
No, Your Honor.
Let me give you some time to talk, but I guess before I do, Mr. Romero, what is the announcement today?
Your Honor, I don't know if we're set for the actual trial on the merits or for the
Yes.
pretrial guideline order. We are. Okay, then I filed a motion to dismiss pursuant to Rule 91A, Your Honor. I don't believe that Mr. Mercado's claim has any basis in law, and in fact, the claim that he's making is against Mr. Vela individually, but I believe that the claim that he's attempting to make is against the company itself. And so that's also the basis for the appeal, Your Honor.
If I understand the rule correctly, I think it has to be filed within a certain amount of time after the service of the first complaint of petition or cause of action. Then the court has a certain amount of time to set it, and then a certain amount of time to rule. And we can go through that process, and then if it fails, we'll set it up for hearing right now, or we can proceed to a final hearing before doing all of that today. So I tell you what, before answering that question, Mr. Mercado and Mr. Vela, let me give you all some time to talk, and then this will be the first contested matter without knowing anything else, the first contested matter on today's docket. All right, so talk to each other, and I'll call this case momentarily.
Yes, sir.
It's Romero, Your Honor.
All right, Mr. Mercado, stand by.
Page 11, number 27.
Emily Espinosa, Esquito Espinosa versus Humberto Martinez, cause number 2026 CVA 960C3. Court marks Mr. Romero present in person, Mr. Long present by video conference. Good afternoon to both.
Good afternoon, Judge.
Emily Espinosa, Esquito Espinosa, Humberto Martinez. Any parties present? Court finds no parties present. Mr. Romero, Mr. Long?
Your Honor, we're here for a pretrial guideline order. I just need dates for 2027. I couldn't locate them on the site. So if you can provide me some dates, Your Honor, and I think I can work with Mr. Long and provide the court with a pretrial guideline order.
Would this be a bench trial or jury trial?
I think we're going to be requesting a jury trial, Your Honor.
It's fine, Your Honor.
Mr. Romero, in what month in 2027?
Maybe around April or May.
Any objection to April, Mr. Long?
No objection, Your Honor.
All right, give us the jury selection, well, sorry, yeah, jury selection on Friday.
That'll be April 16th at 8 a.m.
And that's voir dire.
Correct.
And then the trial date commencing on
19th of April at 8 a.m.
That's a Monday. Now, give us a jury selection conference. That's where everything begins being in person. Give us some time in mid-March to early April.
March 30th at 2 p.m.
And then give us a final pretrial hearing, not a pretrial hearing, but a final. So you can have many before that, but your final pretrial hearing, give us a February setting.
February 16th at 2 p.m.
Any objections to any of these dates, Mr. Romero?
What was that last date, Your Honor? The February 16th was the what?
Final pretrial hearing, February 16th at 2 p.m.
Yes, Your Honor. No objection.
Any objection to any of these dates, Mr. Long?
No objection, Judge. Thank you.
All right, so just circulate these into a pretrial guideline order. These are the orders of the court. That pretrial guideline order is due to the court honor before.
August 31st at 12 noon by submission.
Anything else on this case, Mr. Romero?
No, Your Honor.
Mr. Long?
Nothing further, Your Honor.
You know what? Let me give you one other date. I don't know what date this lands on, but let me give you a mediation date, and that'll be so by the beginning of March 1st. So when you come back for your final pretrial hearing, if you haven't resolved it by then, just come back and tell the court you've already mediated or you have a date before March the 1st. Mr. Romero, Mr. Long, good luck to both of you and your clients on this case. Good luck.
Thank you. May we be excused?
And Mr. Long. Well. Next is Council Jonathan Garcia Davalos, page 2, number 3.
In the estate of Maria Guadalupe Lopez, cause number 2022 PB4 109L2, court marks Mr. Garcia Davalos, present in person. Good afternoon.
Good afternoon, Your Honor.
Elisa Mar Soto, Jose Luis Castillo, Olivero Canales. Any other lawyers present?
Good afternoon, Judge. Ms. Soto here on Zoom.
Ms. Soto, the court marks you present. You're participating by video conference. Mr. Castillo, Mr. Canales, any other lawyers? Court finds Mr. Castillo and Mr. Canales not present. Patricia Garcia, Maria Guadalupe Reyes, Jesus Manuel Lopez. Any parties present? Ms. Garcia, Ms. De Reyes, please step forward. And court marks Mr. Jose Luis Castillo's device logged in. Speaking to the microphone and tell the court, are you Patricia Garcia?
Yes, Patricia Garcia.
Welcome to court, Ms. Garcia. The court marks you present in person. As you can see from this device, your lawyer is present and participating by video conference. Speaking to the microphone and to the court, are you Maria Guadalupe de Reyes? Welcome to court. The court marks you present in person. The person to your far right is your lawyer. Ms. Soto, Mr. Garcia Davalos, what is the announcement?
Your Honor, before, just to make sure that I believe there might be some errors online. I don't know.
Anybody else present on the case of Maria Guadalupe Lopez?
Yes,
Tell the court your name, please.
Natalio Lopez Jr.
Mr. Lopez, are you here on the case of Maria Guadalupe Lopez?
Yes,
And what is your relationship to Ms. Lopez?
I'm her son.
All right, and who is the person on your left?
That's my brother.
What is your brother's name?
Agustin Lopez.
Mr. Lopez and Mr. Lopez, welcome to court. The court marks you present. You're participating by video conference. Is there any other person with you, Mr. Natalio Lopez?
No, that's it.
No.
Is there any other person present in person or by video conference on this case? So noted. Ms. Soto, Mr. Garcia Davalos, what is the announcement?
Your Honor, I filed a motion for new trial. I believe that Ms. Soto filed a response. And so this will be a contested matter that will need to be heard today so that the court can still have jurisdiction over the case.
Ms. Soto?
That's correct, Your Honor.
I'm still going to ask that you all talk to each other, although with a motion for new trial, it's either granted or denied. There's no in-between point. So at least talk to each other. But yes, you are listed now as the second contested matter this afternoon. All right, so stand by, please.
Thank you. Your Honor.
Yes, thank you, Judge.
Next down is Council Robert Freeman, page 6, number 14.
Martiano Ruiz versus Jesus Cadena and all other occupants. Cause number 2026 CVD 62L2. Good afternoon, Mr. Freeman.
Good afternoon, Your Honor.
Court marks you present in person.
Yes.
Give me 1 second. Please step in front of the microphone and tell the court your name.
Martiniano Ruiz. Martiniano Ruiz.
Welcome to court, sir. The court marks you present in person. The person to your left is your lawyer. Jesus Cadena, are you present?
I'm present for you.
Court finds Jesus Cadena not present in person, not present by video conference. Mr. Freeman.
Your Honor, this is an appeal from an eviction case in the JP court filed by Mr. Cadena against Mr. Ruiz. Mr. Ruiz is the plaintiff in the original case. And since Mr. Cadena is not here, I would ask the court to dismiss the case in order the eviction that was granted in the JP court originally. And unless we have to come and prove up our eviction case all over again today.
Well, I can do a few things. I mean, I've already called this case and ostensibly, so Mr. Friedman, Mr. Cadena was was the non-prevailing party in the underlying justice of the peace case. He has appealed. This is a trial de novo. The burden in any event still rests on Mr. Ruiz.
Correct.
Yeah, I mean, procedurally, I mean, I could dismiss for want of prosecution and then hope that the Justice of the Peace reinstates their order. I can't do that unilaterally. They would need to do that. As you wish, I'm happy to do either. Whatever you believe is procedurally more sound. I can dismiss for want of prosecution, or you can present your case and you're gonna have a free floor, I guess, with no other persons present.
Whether you didn't have determined the facts of the matter, Your Honor.
Okay, then let me list this as the third contested matter this afternoon, and I'll call this case momentarily.
Next is Counsel David Garcia, page 1, number 2, is it item?
This is in the guardianship of E.G.E.R.T. Jr. and A.R.A. Cause number 2020 PB 641L2. Court marks Mr. Garcia present in person, Ms. Elisamar Soto present by video conference. Lori Moreno, Oscar Moreno, any parties present?
Your Honor, this is Ms. Soto again. My client just checked that she's in the court's waiting room. Virtual waiting room.
Court is admitting device labeled Lori Moreno. Ms. Moreno, the court is asking that you unmute your device and you start your video. Your case has been called. Are you Lori Lamar Moreno?
Yes, I am. I am Lori Lamar Moreno, Your Honor.
Welcome to court, Ms. Moreno. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer, Ms. Soto, is also present and participating by video conference. Ms. Soto, Mr. Garcia, what is the announcement?
Your Honor, so
The
Hi,
announcement?
Mr. Garcia. Your Honor, I did file the application for successor guardianship over the children. One of them has aged out. There's 2 that are still minors. And I do have that pending with the court. I don't think we finalized all of the prerequisites, but I that has been submitted. If I can just maybe get like a 30-day recess so that I can complete the requirements.
Yeah, yes. First, I think the JBCC training certificate should be available to your client relatively soon after she takes
Yes.
the requirements. The background check is a little trickier, but I'll send a note over to the JBCC and see if what amount of time they believe would take to have that criminal background check in. So I tell you what, give me a compliance hearing in 45 days.
Next available, October 8th at 9 a.m.
Now, if for whatever reason that criminal background check comes back before then, just notify the court and we'll also receive it. So we'll flag the case to get it heard sooner.
Okay.
Anything else on this case, Ms. Soto?
That's all I have on this matter, Your Honor.
Mr. Garcia?
Just to be clear, Judge, at the beginning, there were 3 wards, one of them aged out, I believe is what she said, but I wasn't having a hard time.
Right. I believe it was JGE who has since aged out.
Okay, I just wanted to be sure. I didn't-
Yeah. Ms. Noriega?
And if I may add to that, Your Honor, being that we still have guardianship over the child that has, or the teenager that has just aged out, will the court prepare an order to do that? Or
Yes, let's
Like
take care of it ourselves. Court will prepare its own order regarding the oldest child aging out. Thank you for that. Do you have any questions for the court, Ms. Moreno?
No, I do not. Thank you so much for your understanding and patience as I'm going through this and getting the guardianship for my niece and nephews.
You're stepping up to the plate in the best interest and for the benefit of your niece and nephew. So I certainly understand that. I look forward to hearing this case on October the 8th. Good luck.
Thank you. I
Judge.
appreciate it.
Yes. Any other
Next.
cases for Ms. Garcia? Mr.
no,
Mr.
Your
Garcia?
Honor.
Good to see you, sir.
Thank you, Judge. May I be excused?
Yes, sir.
Next is Counsel Roderick Lopez, page 10, number 24.
Perez versus Cornerstone Fitness, cause number 2025 CVF 2302C3. Court marks Mr. Lopez present in person. Good afternoon.
Good morning, Your Honor. Good afternoon.
Dalby Fleming, are you present? Court finds Mr. Fleming not present. Mr. Lopez?
Your Honor, I believe we've reached a settlement on this case. So if we could set it for 30 days for some sort of entry or
I think after the last hearing, the court scheduled this for dock control on October the 6th.
okay,
October the 6th at 2.
so we'll keep that date.
Sounds great. Are there any other cases for Mr. Lopez?
No, Your Honor.
Good to see you, counsel.
Oh, I'm
There-
sorry.
There's one
page-
more.
Yes, page 11, number 26.
That is Angelica Arispe versus Kora Hollers LLC and Carlos Rodriguez, cause number 2026 CVA 742C3. Court marks Mr. Lopez present in person. Ezequiel Reina, Mark Macias. Any other lawyers present?
Chad Williams for Mark Macias, law firm of Langley Benak via Zoom.
Good
Mr. Williams, welcome to court. The court marks you present by video conference. Ms. De La Garza, go ahead.
Yes, Judge, I'm here with the law office of Ezequiel Reina on behalf of the plaintiffs.
Welcome to court as well. Ms. De La Garza, court marks you present by video conference. Angelica Arispe, Cora Hollers, Carlos Rodriguez. Any parties present? Court finds no parties present in person or by video conference. Counsel, what is the announcement?
Your Honor, I contacted the mother of the minor in this case. She told me she was not available today. We were trying to get this set up for a minor settlement hearing. There has been a judgment that's been circulated by defense counsel. I believe everyone has signed off on it. I think the only thing would be to prove up the settlement hearing. I did not get an indication from Ms. Arispe when she would be available. Maybe plaintiff's counsel can address that.
Ms. De La Garza?
Judge, we have not been able to get in contact with her today, but we'll continue to follow up. If I can work with Mr. Lopez to see if we can come up with a date that's agreeable with the court to reset for the prove up. If the court
Well,
is
we
okay.
should do that now so that everybody has notice, at least on the record. Ms. De La Garza, how much time do you believe would be reasonable and necessary?
I think anywhere between a week or 2 weeks is fine, Judge. I'll get in contact with the client.
All right, give us the next available, Ms. Noriega.
October 8th at 9 a.m.
All right, any objection, Ms. De La Garza?
No, Judge, that works.
Mr. Williams?
October 8th, Your Honor, was that the date?
Yes. October the 8th at
That's-
9 a.m., correct?
That's fine for me, Your Honor.
Correct, Your
All
Honor.
right, any objection, Mr. Lopez?
No, I was just trying to see if we could set it for the same date on the case that we just heard.
Oh, that's,
6th, the other date, Your Honor,
oh, any objection to October the 6th, Ms. De La Garza?
at 2 p.m.
At 2 p.m., Mr. Williams?
October 6th at 2 p.m. Then I have a conflict on that date, Your Honor.
Okay, October the 8th works. We'll make it work.
October the 8th at 9 a.m. All right, I'll call this case then. Good luck to all.
Thank
Thank
you.
you.
Thank you, Your Honor.
Good to
May I
see
be
everyone.
excused?
Yes, sir.
Thank you.
I have Juan Hernandez, but I don't know what case he's here for. I don't have him on the agenda.
This is in page 3, and it's in the estate of Ismael M. Luhan.
This is the estate of Ismael Luhan, cause number 2024 PB428L2. Mr. Hernandez, who do you represent?
I represent Mr. Luhan.
Oh, I understand.
Son.
Court marks you present in person, Mr. Hernandez, Marisela Rangel, or Miguel Aron Lujan. Any other persons present?
No, Your Honor, I think the deadline was to turn in the inventory appraisement and the list of claims, and I just wanted to make sure that.
Has that been turned in? That's why I missed it. All right, I'll review it. Thank you so much, Mr. Hernandez. Any other cases for counsel? It's good to see you, Mr. Hernandez. Have a great Tuesday.
You too.
Counsel Robert Freeman, and he's standing in for counsel Carlos Castillon, and that is page, thank you, page 13, number 30.
Commerce Bank versus Heriberto Alcantar, Trinidad Lara III, Philip Raul Munoz, and for Alarm Trucking LLC. Cause number 2026 CVK 928C3. Court marks Mr. Freeman present in person. He's here on behalf of Mr. Castillon. Daniel, Walter, or any parties? Any other persons present on this case? Court finds no other persons are present. Mr. Freeman?
Your Honor, Mr. Walters emailed my client, Mr. Castellano, about 2 o'clock this morning from Switzerland. His father passed away and was just getting the body released from the morgue today in Switzerland for burial. And so he asked for continuance. He thinks his clients can work it out with Commerce Bank. And so they're asking for 30 days or 6 weeks in order to have time for him to come back from Switzerland and work it out. And we have no objection to that, Your Honor.
I'm sorry, remind the court, obviously, counsel has the court's condolences. Remind what you said about the timeline. How much time are you requesting?
36, I heard October 8th was what you were setting. I think October 8th would be good for us.
Is that still available, Ms. Noriega? October the 8th at,
Yep.
All right, we'll come back on that day for this case.
Sounds good, Your Honor.
Before we continue, Ms. Noriega, your microphone is in and out.
Oh, is that better?
Yes.
Thank you. Next is Counsel Joe Benavides. I don't know if he's standing in for one of the cases, Your Honor.
Mr. Benavides, what page and case are you here for?
Good afternoon, Your Honor. On the factor matter,
Page.
Give us a cause number.
Yes.
yes, sir. 1 second, I pull that up.
Any other attorney in front so that I can.
Your Honor, it is cause number 2025 PB 7000079L2 in the estate of Ector Jose Factor.
Have that on my document. Definitely.
Case set for August 18th at 2 for inventory. And it looks like that.
I believe that was filed already, Your Honor.
That's why I didn't make it onto the docket. It's been filed and I believe pre-approved. Nope, it's pending approval. All right, I'll review it and approve as required. Any other cases for Mr. Benavides?
No, Your Honor, that is all.
Anything else, Mr. Benavides?
That's all, Judge.
It's good to see you. Have a great Tuesday.
Thank you, likewise.
Next is page 7, number 17 with Counsel Jose Luis Castillo.
I'm present,
The
Judge.
estate of Ortensia Ramirez. Cause number 2026 PB4 5702. Good afternoon, Mr. Castillo.
Good afternoon, Judge. Judge, my video, I think, has been blocked or disabled.
I recognize the voice. This is an application hearing. Mr. Castillo, what is the announcement?
Your Honor, we are ready to proceed with the application.
Felipe Ramirez IV, are you present?
He is present. He's sitting right here next to me, Judge.
Is there any other device that he can use so I can
Judge, I can log off and log back in, Judge.
all right. We'll place this case on hold.
Okay, no problem, Judge. Thank you.
Thank you.
Next is Counsel Christina Hale, and that case is on page 7, number 16.
This is the estate of Marina de la Garza, cause number 2026 PB5 5L2. Good afternoon, Ms. Hale.
Good afternoon, Your Honor. We
Court
do
marks are
have.
present. You're participating by video conference. Court marks Ms. Elizabeth Vela, also present and participating by video conference. Ponacio de la Garza, are you present? Excuse me.
De la Garza.
Ponciano de la Garza, are you present?
Yeah, we're present. Yeah, we are here.
Welcome to court, Mr. De La Garza. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present by video conference. Who is the person on your left?
Well, she's my wife, Juanita de la Garza, San Juanita de la Garza.
She's an applicant, Your Honor, as well.
Welcome to court, Ms. De La Garza. The court marks you present, participating by video conference as well. Ms. Hale, go ahead.
Thank you, Your
Your
Honor.
Honor, we're ready to proceed, Your Honor. At this time, we're asking that the court approve the declaration of heirship and appointment as co-independent administrators of Mr. Ponciano de la Garza as well as San Juanita Flores de la Garza. In support of the application for heirship, we are asking that the court take judicial notice of the entire case file. That includes the original death certificate, attorney ad litem report, and the affidavits that were submitted by the two disinterested witnesses. And in support of the administration of the estate, we do have the testimony today of the applicants, Ponciano and San Juanita de la Garza.
Very well. Ms. Vela, are you also ready to proceed?
Yes, Your Honor.
All right, Mr. De La Garza and Mrs. De La Garza, the court is going to ask that you raise your right hands.
Okay.
Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, yes.
I do.
Yes, Your Honor. I do.
All right, you may lower your hands. Ms. Hale, go ahead. One witness at a time, please.
Mr. De la Garza, I'll begin with you. Please state your full name for the record.
Ponciano de la Garza.
And Mr. De la Garza, where do you reside?
Pardon me?
Where do you live? What is your address?
In 3220 Barrios Street in Laredo, Texas.
And what is your relationship to the decedent, in this case, Marina de la Garza?
I'm sorry. My relationship, she's my stepdaughter. She was my stepdaughter. I'm sorry.
Okay. And what was the date that she passed away?
On October 13, 2023.
And do you know how old she was at the time of her death?
She was 43.
And
say that again.
43.
Thank you.
And do you know if Marina died without a will?
Yeah. No, she has no will.
And where did she live throughout her life or at the time of her death?
3220 Barrios Street.
So she lived with you, correct?
Yeah, that's same. Yeah.
And how long had she lived with you?
43 years, so the whole life.
Okay. And did Marina have any children at the time of her death?
Yes, okay. One child.
One child, and was that her biological child?
Yes, a biological child.
And what is the name of that child, please?
Lorenzo de la Garza.
Okay. And how old is he?
It's gonna be 10 September.
Before we continue, there's overlap in the witnesses. The Ms. De La Garza is answering at the same time.
Ms. De La Garza, since Mr. De La Garza is testifying, please don't say anything.
Okay. Thank you. I'm sorry.
It's okay. Ms. Hale, go ahead.
Okay. And where does Lorenzo live at this time?
At the same address, 3220 Barrios.
Okay. So he lives with you, correct?
Yes, with us.
And how long has he lived with you?
The whole life, almost 10 years.
Okay. And at this time, who has custody or conservatorship over Lorenzo?
We are, my wife and I.
Okay. And did Marina have any other children besides Lorenzo?
No.
And was she ever married?
No, never.
Okay, and at this time, are you asking that the court determine heirship and appoint you as a co-independent administrator?
Yes, ma'am.
Now, did Ms. De La Garza, Marina De La Garza, did she have any significant debts or assets at the time of her death?
No.
Okay. And is the reason that you're seeking the administration at this time is so that you could pursue a survival action, which is required that you have this particular filing approved? Is that correct?
Yes, that's correct.
And is there anything that would disqualify you by law from serving as an independent administrator?
No, ma'am. No.
And would you promise to faithfully manage the estate if appointed?
Yes.
Okay. I have no further questions of Mr. De La Garza.
Ms. Bella, do you have any questions for Mr. De La Garza?
You're not interested in the estate, correct?
Not personally, that's for my grandson.
Okay. thank
My
you.
interest is my grandson.
That's all.
Your next witness, Ms. Hale.
Okay, Miss San Juanita Flores de la Garza, I'm going to go ahead and call her. And at this time, Miss de la Garza, could you state your full name for the record?
I am San Juanita Flores de la Garza,
Okay, and where do you reside?
3220 Barrios, Laredo.
And what was your relationship to Marina?
I am her biological mother.
And did she reside with you at the time of her death?
Yes.
And how many children did Marina have?
One child.
And that's Lorenzo, correct?
Lorenzo de la Garza.
Okay. And what's his date of birth?
His birthday is September 27, 2017.
So he's 10 years old, correct?
I'm sorry, 16. September 27, 16.
So that would make him 10 years old, correct?
Yes, right.
And who is Lorenzo's biological father?
I don't know. I think he died last year.
Okay. And so at this time, you are the only relatives that he has in his life, Lorenzo, correct?
Yes, correct.
And did Marina, your daughter, have any other children besides Lorenzo? Adopted or biological?
No, ma'am.
And was she ever married?
No, ma'am.
Okay. And after Marina passed away, did you and your husband, Ponciano, file a modification of his conservatorships to give you rights, duties, and obligations towards him?
Yes.
And in fact, did the court grant you that conservatorship?
I'm sorry, can you repeat that?
Did the court grant you a conservatorship over Lorenzo?
Yes.
And do you know if Marina died without a will?
Yeah, she died without a will. Yes.
Okay. And where did she pass away?
Ma'am?
Where? Where did she pass away?
Doctor's hospital.
And as managing conservator of Marina's sole heir, do you agree on behalf of him that an administration is necessary and would consent to this administration on his behalf?
Yes.
And are you qualified by law to serve as an independent administrator, and do you promise to faithfully manage the estate if appointed?
Yes.
I have no further questions, sir.
Bella, any questions for Mrs. De La Garza?
No further questions.
Right, report and recommendation, Ms. Bella?
Yes, I filed my attorney ad litem report. I interviewed the co-applicants as well as the two disinterested witnesses who were decedent's aunts. They confirmed all of the information in the application. I also conducted an independent investigation where I reviewed the published obituaries for Miss Marina de la Garza and confirmed the information about her heir's biological father's rights being terminated and co-applicants being appointed conservators of her heir. And so it's my opinion that the application is true and correct, and her son Lorenzo is her only heir.
And before I cede the floor to Ms. Hale, is there anything you would like to tell the court or request from the court regarding fees?
Yes, based on my investigation and the work performed in my role as attorney ad litem, I'm requesting the fee of $750.
Any response to that, Ms. Hale?
No objection, Your Honor. I agree with that.
All right, closing request, Ms. Hale.
Again, Your Honor, we'd ask that you take judicial notice of the entire file and that you accept the testimony of the applicants, in this case, Ponciano de la Garza, as well as San Juanita Flores de la Garza, and find that the only heir of Marina de la Garza is, in fact, her son, Lorenzo de la Garza. And in addition, that you find it's in the best interest of the estate and of that child to appoint them as co-independent administrators And we'd ask that you waive the bond based on the fact that there's only, the only distributee is the child who's the managing conservator of that child, or is in fact the applicant's. And if not, we would alternatively ask that you set a reasonable bond.
If this court were to set a bond, what numerical value would it have to evaluate? In other words, if this person didn't have a large estate but is pending a claim, what would you suggest, Ms. Hale?
Your Honor, I would defer to the court because at this point it's hard to calculate.
Right. All right. Mr. De La Garza and Mrs. De La Garza, in the case of your daughter and stepdaughter, cause number 2026 PB5 5L2, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to both determine her heirs and to name administrators in her estate. The court hereby takes judicial notice of the entire case file, which includes Ms. De La Garza's original death certificate, the citation by posting, the citation by publication with the Laredo Morning Times and with the Office of Court Administration. The court has also takes notice of the attorney ad litem report that has been stated here orally as well by attorney Elizabeth Vela, the waivers of both co-applicants for the minor child, the attorney's certificate of service, and the statement of facts by the two disinterested witnesses. The court finds that Ms. De La Garza passed away on the 13th day of October 2023 at the age of 43, having left no will, not married, but had one son, a 10-year-old. The court finds that she passed away without a will. The court finds that there is a necessity to administer her estate. The court finds that you are both each qualified and you are not disqualified from serving. Now I was going in order of the order, and I should have done it in reverse because first the court needs to find an heirs based on the report and findings and testimony of both of you and the report of Ms. Vela. The court finds that Ms. De La Garza left one heir, Lorenzo De La Garza, her son. Heirship is so declared. For all of the other reasons already stated by the court finds that there is a necessity to administer your daughter's estate. The court names both of you as co-independent administrators and will cause letters of testamentary to be issued out to you. I'm issuing out a bond, and it's nominal in the amount of $500, and it's a surety bond. The court has signed the order granting your request and tendering the original to the clerk's office. The inventory on your daughter's case is due to the court honor before November the 12th, 2026 at 2 p.m. One other thing, the court finds that in performance of her services, Ms. Vela has performed legal work in this case. The court finds that $750 is reasonable, necessary, and agreed to. All right, Mr. De La Garza, Ms. De La Garza, the court has granted your request in full. Mr. De La Garza, do you have any questions for the court?
No, sir. No, Your Honor. No.
Ms. De La Garza, do you have any questions?
No, thank you, Your Honor.
Anything else on this case, Ms. Hale?
No, that's all we have, Your Honor.
Ms. Noriega?
That is all for both counsel, Your Honor.
Good to see you both. Have a great Tuesday.
Thank you. Bye-bye.
Your Honor.
Next is counsel Christopher DeLeon, page 12, number 29.
Axiom Acquisition Ventures LLC versus Roberto DeLeon, cause number 2026 CVH 529C3. Good afternoon, Mr. Deloney.
Good afternoon, Your Honor.
Court marks you present by video conference. Roberto DeLeon or anybody else? Is anybody else present on this case? Court finds no persons are present on this case other than counsel Deloney, and court takes judicial notice that defendant was served with process on March the 25th, 2026. Mr. Deloney, what is the announcement?
Yes, Your Honor, we're just moving for a default judgment in this matter. We did not show the defendant has filed an answer. We submitted to the court plaintiff's motion with the attachments proving up the account and the debt. We're asking the court to enter a default judgment for plaintiff in the amount of $33,309.58 as principal. Attorney fees in the amount of $1,750. All cost support and post judgment interest at the current legal rate of 6.75%.
In cause number 2026 CVH 529C3, the court hereby takes judicial notice of the entire case file. The court sees that we are set for a motion for default. The court takes notice that defendant was served with process on March 25th, 2026. The court reviewed the file in advance of this hearing. Nothing was filed, no answers, no appearances. The court takes notice that defendant is not present in person, neither is he present by video conference. The court finds, based on the filings, that Axiom Acquisition Ventures LLC is hereby entitled to a default judgment against defendant DeLeon in the amount of $33,309.58. The court sees that there's also a request for attorney's fees. The court finds that $1,700 is reasonable and necessary in this case. And the court will grant all the relief requested, including the cost of the court and post-judgment interest. The court sees that there is a proposed order on file. The court has reviewed it. It is in due form. I have signed it, and I am tendering the original to the clerk's office. Default judgment is granted. Anything else on this case, Mr. Deloney?
No, thank you, Your Honor.
Any other cases for Mr. Deloney?
No, Your Honor.
Have a great Tuesday.
All right, thank you, Judge.
Next is counsel Jeffrey Czar. Mr. Czar is not listed on here, but his cases are as follows.
Case 19, the state of Texas versus Jose Roberto Valdez, cause number 2026 CV3 4602. Good afternoon, Mr. Czar.
Good afternoon, Your Honor.
Court marks you present by video conference. Jose Roberto Valdez, are you present? Court finds Mr. Valdez not present in person, not present by video conference. Mr. Czar?
Yeah, we would ask for a pretrial date. We're going to try to reach out to him and see if we can come to some agreement.
Give us a pretrial hearing date, Ms. Noriega.
That'll be October 8th at 2 p.m.
So ordered. Page 8, case 20, the state of Texas versus Cynthia Ochoa, cause number 2026 CV351L2. Cynthia Ochoa, are you present? Please step forward. Please pull up close to the microphone and tell the court, are you Cynthia Ochoa?
Yes, I am Cynthia Ochoa.
Welcome to court, Ms. Ochoa. Ms. Ochoa, do you have a lawyer?
No.
Will you be going forward today without a lawyer?
Yes.
Mr. Czar, what is the announcement?
Yeah, no, we just need a phone where we can reach her so we can have a discussion about this particular case prior to the pretrial setting.
Ms. Ochoa, what is a phone number that the county attorney's office can communicate with you?
It will be 956-281-3745.
All right, we'll come back for a final pretrial hearing on
October 8th at 9 a.m.
October the 8th at 9.
Yes, Your Honor. I believe in the last case I said 2 p.m., but
Yes.
October 8th is 9 a.m.
October the
Is it
8th
9 o'clock, Your
at
Honor?
9 a.m. Yes, both cases are set for October the 8th at 9. Ms. Ochoa, you need to know a couple of things. Since you are not represented by a lawyer, that means that Mr. Czar can't communicate with you. When you talk to him, you need to know and understand that he is not your lawyer. He cannot and he will not provide you any legal advice, but he can make you an offer on behalf of the county attorney's office. And you can come back on October the 8th and tell the court whether you agree to that offer or you disagree with that offer.
Okay.
Do you have any questions for the court, Ms. Ochoa?
No.
I wish you well. Have a good day. Page 8, case 21, the state of Texas versus Agustin Martinez Garcia, cause number 2026 CV353L2. Court marks Mr. Czar present by video conference. Agustin Martinez Garcia, please step forward.
Good afternoon.
Are you Agustin Martinez Garcia?
Yes, sir. Yes, sir.
Welcome to court. The court marks you present in person. Mr. Martinez Garcia, do you have a lawyer?
No.
Will you be going forward without a lawyer?
Yes. Yeah.
Court marks you self-represented. Mr. Czar?
Yes, Shannon, we're gonna need a phone where we can reach him, phone number. And a pre-trial date.
Give us a final pretrial hearing, Ms. Noriega.
October 8th at 9 a.m. And if I can have an email, Your Honor.
Mr. Martinez Garcia, what is your email address?
It's AugustinMTZG@gmail.com.
And Mr. Be on the lookout in your emails, because if the court needs to send you any information, any notices, it'll go to that email address. Similarly, if Mr. Czar, on behalf of the Webb County Attorney's Office, needs to send you information, requests, or notices, it's likely to go to that email address. Mr. Martinez Garcia, what is a phone number that Mr. Czar can communicate with you?
956-401-4920.
Did you get that, Mr. Czar?
Yes, sure, I believe I did.
Right, Mr. Martinez Garcia, you're going to come back to court on October 8th at 9. Between now and then, communicate and talk to Mr. Czar. As you talk to him, you need to know and understand that Mr. Czar, he is not your lawyer. He cannot and he will not provide you any legal advice, but he can make you an offer on behalf of the county attorney's office. And you can come back on October the 8th and tell the court if you accept the offer or if you reject that offer. Do you have any questions for the court?
No question.
All right, we'll see you on October the 8th. I wish you well. Have a good day.
Page 9, number 22.
State of Texas versus Robert Lee Beltran, cause number 2026 CB360L2. Court marks Mr. Czar present by video conference. Robert Lee Beltran, are you present? Mr. Beltran, pull up in front of a microphone and tell the court, are you Robert Lee Beltran?
Yes, sir.
Welcome to court, Mr. Beltran. The court marks you present in person. Mr. Beltran, do you have a lawyer?
No.
Court marks you as self-represented. Mr. Czar?
Yeah, Your Honor, we still need a phone for the appellant.
Mr. Beltran, Ms. Noriega, does the court have Mr. Beltran's email address?
No, Your Honor.
Mr. Beltran, what is your email address?
It's Robert Beltran 2014 @yahoo.com.
Right, as you heard with the previous case, just be on the lookout in your emails. If this court needs to send you any information or notices on this case, it'll go to that email address. Likewise, Mr. Czar can also send you information and notices or requests at that email address. Mr. Beltran, what is the phone number that Mr. Czar can communicate with you?
361-738-9883.
Just in case we missed it, what is it one more time?
361-738-9883.
It was what, Your Honor? The first part of that? I don't think I got the.
361.
It's what?
361.
361.
738-9883.
Got it, Your Honor.
Right, so you've heard this at least once or twice before, Mr. Beltran, but communicate, talk to Mr. Czar. He's going to make you an offer on behalf of the county attorney's office. You'll come back on October the 8th and tell the court whether you accept or you reject that offer. He is not your lawyer, which means he will not provide you any legal advice, but he can make you an offer. Don't feel pressured to accept it, but you should think about it and then tell the court whether you want to accept or not. Do you have any questions for the court, Mr. Beltran?
Do I have to be present for that date, or is it over the phone or something?
Well, on that date, you can appear in person, you can appear by video conference, but Mr. Czar, there's a chance that you're going to provide this information in writing. He can sign off on it, and that would forego the necessity of being at the hearing, correct?
That's correct, Your Honor.
Yeah, so he's going to send you that information in writing. If you decide to accept it, you'll sign off on it, and he will file it with the court. So there wouldn't be a need for you to attend the next hearing if you agree and you sign off. If you disagree, that's okay. You can come back and tell the court. Do you have any other questions, Mr. Beltran?
No.
All right, I wish you well. We'll see you possibly on October the 8th. Good luck.
And that is all for Mr. Zard today, Your Honor.
Good to see you, counsel. Have a great
Thank
Tuesday.
you, Your Honor. Have you excused, Your Honor?
Yes, sir.
This is Counsel Francisco Tamez, page 1, number 1.
This is in the matter of Lorenzo Sto Jr., cause number 2004, PB 640L2. Court marks Mr. Tamez present by video conference. Ms. Lanessa Garcia present by video conference. Diana Aguilar, are you present? Court finds Ms. Aguilar not present. Are there any other parties present on this case?
Not identified, Your Honor, online.
All right, counsel, what is the announcement?
Your Honor, there's a couple of things pending today. One was the application to convert, or excuse me, for substitution of the guardian of the person. The other one is a application for payment of attorney's fees that I filed. I think there was some communication issues on our end, and so the applicant is not available today. So I think Ms. Garcia will be asking for a continuance of that application. I am ready to proceed with my application, Judge. At this point, I approve of the substitution of guardianship of the person. I think the work on my end has been completed. I think once the application is approved, then this guardianship can proceed on its annual reporting basis.
That's correct, Judge. And unfortunately, my client, there was a communication problem between my office and my client. She was not able to get off of work today to be able to participate in today's hearing. So I would ask to reschedule at the court's convenience so that I can give my client the opportunity to get that time.
Yeah, can you hear me?
Sorry, Judge, I'm in another Zoom. Let me lower that. I apologize, Judge. Doing mediation as well. Sorry about that.
Understand that the last part of your comment or thought or statement was that we would come back for the purpose of appointing that successor guardian?
Yes, sir. Yes.
Well, you're here on her behalf. Mr. Tamez has filed an authenticated claim requesting attorney's fees in the amount of $5,730 that he says are reasonable and necessary. Any thoughts, comments, questions, or objections to that request?
Absolutely no objections. I believe those were reasonable and necessary. I know Mr. Tamez did a lot of work in reviewing the file and making recommendations to the court. So I think they should be approved.
All right. The court has received, reviewed, and considered the second authenticated claim for payment of attorney ad litem's fees. The court hereby approves those, finds that those are reasonable and necessary. In this case, the court has received an order, signed that order, and tendering the original to the clerk's office. We'll come back. Ms. Noriega, give us a date for that application hearing.
That'll be October 8th at 9 a.m.
Any objection?
No, sir.
All right, we'll come back on that day. Anything else on this case, Mr. Tamez?
No, Your Honor.
Ms. Garcia?
No.
All right.
Your Honor, I do.
Ms. Noriega?
I just have a question in reference to who would be filing a report for the upcoming annual report, and I believe it's the estate of Mr. Soto. We do have it coming up for the end of August.
It's a great question. Thank you.
And also
Thank you for that. I think Mr. Romero had been representing the current guardian. So I think it's gonna Mr. Romero's client will have to provide that last report and I guess that last annual account.
Fortuitous that Mr. Romero was present in person.
Thank
Mr.
goodness.
Romero?
Yes.
You're very fortuitous. No, I just want to make sure you're on the last order that I submitted. I just need to double check to make sure that it didn't say that my services had terminated, or that I had been terminated to serve as ad litem.
Does anybody here know the answer to that question?
I don't, Your Honor, but I have no objection for a modification of that order, if that's the case. I think Mr. Romero is familiar with obviously the file prior reporting, and the court recall that there was a need to also submit updated statements from the trust account. And so Mr. Romero's office and my office worked on making sure that he added those updated statements.
I tell you what, two things. First thing, Ms. Rodriguez, did you want to make a comment?
Yeah, Your Honor,
Give me one second. Ms. Rodriguez?
Yes, Your Honor. I was looking at the motion in the order regarding the ad litem fees. It is requesting that the county pay for it.
Oh, no. Let me correct that. Thank you. I didn't realize I had done that.
On page 2.
Okay, let me make that correction. I'll resubmit it, Judge. As you know, the Supplemental Needs Trust has those funds available to assist the ward. So my apologies. The application itself does say that the court has authority to adjudge those costs to be paid from the Lorenzo Soto Supplemental Needs Trust. It was just an omission then on the order. Thank you for catching that. Let me resubmit it.
3 small words at the very bottom. I just now saw that too. Thank you, Ms. Rodriguez. The application, excuse me, the second authenticated claim has already been granted. The orders are due for that on or before.
August 31st at 12 noon by submission.
All right. Mr. Romero, you were about to advise the court?
Yes, Your Honor. So on the order from March of 2026, the last paragraph stated that I was terminated as the attorney ad litem.
We can either do one of two things, folks, since if we want to follow that order, which would probably be a good idea, then perhaps Diana Aguilar, who's going to step into those shoes. In the alternative, what I would suggest, I really don't want to run afoul of the reporting requirements. What I would suggest is this, Mr. Romero, is to meet that August 31st deadline, file a supplement to your work. And file that report as a supplement with a supplement request for whatever amount of time it took you to do that work. So it's not an ongoing obligation. It's just a supplement to the work that you were already ordered to do while you fill the gap until someone else is appointed. So it's not a reappointment or a reopening. It's just kind of like discovery, right? You have a duty to continue going until you're done.
Okay.
Thoughts, comments, questions, or objections to that, Ms. Garcia?
I think that's a great idea, Judge. Thank you.
Mr. Dames?
No, Judge, I agree.
All right, I'll call this case on October 8th at 9. Thank you all.
And I'll resubmit that order right now, Judge, as soon as I get out.
All right. Thank you.
Just for the record, Your Honor, the reporting that I will be submitting is from what date to what date?
Ms. Noriega?
That'll be for the 25th, right, 25, 26, which would be August 13th, 2025 to August 12th, 2026.
Because then which one did I submit?
You submitted the August 13th, 2024 to August 12th, 2025.
5. Okay.
Correct.
All right, thank you all.
Next case from Mr. Tames is page 2, number 4.
This is in the matter of Enrieta Bautista, cause number 2023 PB 699L2. Court marks Mr. Tames present and participating by video conference. Ms. Lanessa Garcia present and participating by video conference. Lina Aurora Bautista, are you present?
She's not present, Judge.
Go ahead.
Your Honor, I think the ward passed away. We need to finalize the final account and submit that to the court, and then start the administration because the ward died intestate. I'm still waiting on some information from our client so that we can finalize that final report.
I'm sorry, what was the date of passing?
She passed away, I want to say, in December.
Yikes, did our review miss that, Ms. Rodriguez?
I believe the court hadn't been notified.
Okay, so we sent out notice so that you know, we sent out notice that there is a new requirement under House Bill 3397. All persons under guardianship that have either been diagnosed with Alzheimer's or second category, all wards over the age of 60, the guardians must take an Alzheimer's training video. So Lina Bautista probably received that notice and is probably looking to come in at the end of the month. So if you all
Okay.
can file something so that when I call the
Yes.
case on August, what is the date of that hearing?
The 27th of August
When
at
I-
9 a.m.
When I call that case on August the 27th, I can put into the record that the court has some information that this ward has now passed.
Okay,
You know, I'll call the case on that date. It's still set for hearing on August 27th at 9. So I'll call it on
Okay.
that date. Then hopefully in our review, we'll pick up a notice that says that, and then whatever is filed, we'll set for hearing. Ms. Noriega?
We can go ahead and have our probate court investigator also look at the obituaries, Your Honor.
Perfect. All right.
okay.
What good thoughts on all fronts? Anything else on this case, Ms. Garcia or Mr. Tamés?
No, sir.
Nothing, Your Honor.
Ms. Noriega?
I believe that is it for Council Tamés. I believe I have.
No,
one
we
more.
have another matter, Judge.
Oh,
I'm sorry, it's the estate of Henry Karansa. Mr. Tamés is on that case.
that's correct.
This is the one that he is on.
Yes.
Understood. Page 7, case 18, the estate of Henry S. Carranza, cause number 2026 PB 735L1. Court marks Ms. Lanesha Garcia present by video conference, Mr. Francisco Tamés present by video conference, Mr. Marcel Knotson present by video conference. Ms. Cigarroa, are you present?
No, Ms. Cigarroa is not an attorney of record in this case. She was initially, but she withdrew. And Mr.
Understood.
Tamés and I substituted in for Ms. Cigarroa.
Understood. Maria Elena Montemayor, Mary Jane Thompson, any parties present?
I don't believe so.
Give
Your
me one
Honor.
second. Give me 1 second to confirm. Ms.
I'm
Thompson, I see
here,
that the
Mary Jane
device
Thompson.
is logged in. I'm going to ask that you unmute your device and you start your video.
Okay, no problem.
I don't know what happened now.
Thank you for calling me. My name's Isabel.
Ms. Thompson, I'm going to ask that you start your video, please.
My video, how do I start my video? Okay. Okay.
Came on there. Mary Jane
Hello.
Thompson.
Yes.
Welcome to court, Ms. Thompson. The court marks you present participating by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. One more time, Maria Elena Montemayor or anybody else. Is any other person present on this case? Court finds no other persons are present. Counsel, what is the announcement?
Your Honor, we filed a motion for continuance of the two matters that were set for today. It's an application for temporary administration and a motion to compel and for sanctions. My client called me yesterday early in the morning. She was not well at all, Judge. And so we had to cancel the scheduled mediation with Allison Haynes yesterday abruptly. And she was very ill. And so she was not able to come to court today and go through many hours long hearing on an application for temporary administration, Judge. We filed a motion for continuance yesterday, but unfortunately, I think I just saw while we were here, well, when we started court at 2, that the clerk had just accepted that motion for continuance. So I'm not sure that Your Honor had seen it.
I hadn't, but the clerk did just right now hand me a copy.
Yes.
Mr. Knotson, your thoughts and position on the motion?
Judge, based on, as an officer of the court, I accept her representation. Ms. Haynes did advise yesterday before the mediation was set to begin that she was very, very sick and not feeling well, and that we were going to get.
Text something.
Please be quiet, Ms. Thompson. That we were going to get new dates. That's why the mediation was set yesterday, so we could attempt to remediate before we had the hearing and hopefully get a settlement. I don't know if Ms. Haynes has given us new dates for later this week or next week, so we can get a mediation date, or the court can maybe order us, give us a date down the road in 2 weeks, and then order us to mediation again with, just so we can complete that mediation before we take up the court's time, because I'm hopeful we can get a settlement and an agreement.
Your Honor, the application for temporary administration, it is very important that we get it set as soon as possible, because one of the issues is the application for relicensing of the subject home health business that is part of the estate. That license expires in mid-November, and the application needs to be done 45 days before the expiration of that date. So someone with authority needs to be able to request the renewal of the license for that company to continue operating, Judge. So if there's availability, no later than 2 weeks from now, that would be great.
And Judge,
give me 1 second, Mr. Tamez, anything else to state on the record?
Not to what Ms. Garcia has represented, Judge. We also have a motion to compel that I was going to argue, but I don't have a problem passing that and having that heard on the same date as the application.
Mr. Knudsen?
And that's fine. The only thing I was going to add, Judge, and I would recommend to my client, and I think I even suggested to the mediator the first time we went with Ms. Haynes, I have no problem with getting a temporary where she's specifically limited to be able to renew it, because apparently she wants to keep it, and we have no problem with an order in that regard. And but the temporary order is limited to that, not to spend assets, not to wind it down or anything of that nature. But I mean, if they want to submit a proposed agreed temporary order limited to that, I have no problem with that. So she can start doing that.
Response, Ms. Garcia?
We can take up that separately, Judge, but we are asking for a temporary administration. As Your Honor is well aware, Mr. Karansa passed away in March. There are many valuable assets that remain unadministered today. And so those need to be taken care of, and someone needs to be given authority, obviously with court supervision, to be able to safeguard, protect, and manage those properties. And that includes a real property worth over $1 million. It includes another condominium property in San Antonio that burned down to the ground, and communications with the insurance company are necessary because that's going to be rebuilt, and that's going to be another valuable asset for the estate. So someone needs authority under court supervision to be able to monitor all that. So I'll work with Mr. Knudsen to get a limited agreement with regard to what we need immediately, but we're not going to forego requesting an appointment of a temporary administrator to properly maintain and preserve the rest of the property, because it can't be hanging out there and unadministered until April when we have our trial date. So this temporary administration can't be limited to just renewing a license. The property needs to be preserved. It needs to be safeguarded. Someone needs to pay taxes and insurance on the real property and have the authority to do so. Someone needs to have the authority to run the business. Someone needs to have the authority to negotiate and safeguard that condominium property in San Antonio, Judge. Those are the main assets here and pretty much what's left in the estate. So I'll work with Mr. Knudsen on getting maybe an initial agreement with regard to what needs to get done immediately, but my client is not going to forego or waive her right to request a broader temporary administration for the benefit of the estate.
And I don't have a problem working with her on that, Judge. One of the things I do want to go back, if the court can put in there on before the reset date that we be ordered to set up a mediation with Ms. Haynes for another half a day to try to get all these issues fleshed out, and maybe she'll be the permanent or the independent executrix if we come to a settlement, Judge. So that we do that beforehand. Ms. Haynes was very flexible to get it done. Unfortunately, she became sick, but we do need to know what the assets are. Information that my client received, there was a $68,000 check supposedly was issued by the insurance company. We don't know where that $68,000 check is. Mary Jane Thompson didn't get it. The Bunks didn't get it. Denise Bunk, the other executrix for Mother's Estate, didn't get it. So who got that check? But anyway, and I asked Mr. Flores, he said he's not aware of a check, and he said to check with Miss Garcia. So the insurance company is mentioned.
And I believe my client, the information I gave Mr. Knotson is that my client forwarded a check to, I believe, to Miss Bunk. So obviously my client could not cash that check. She had absolutely no authority to do so. But my client doesn't have custody of that check. In any case,
we're now all delving into specifics of the things that should and will be argued at a later date. But the issues are certainly well framed. I tell you what, let's do a couple of things. First, the court is going to schedule this temporary administration for September the 1st at 1 p.m. You'll have a very limited amount of time before we go straight into our family law docket. The parties are hereby ordered to mediate with Ms. Allison Haynes before September the 1st, if capital I, capital F, she is available, not anyone else. If she's available, everybody's ordered to mediate. If she is not available, the first question the court's going to ask on September the 1st is, what date is she available, and everyone else? That's the first thing that the court needs to hear on the record, whether you mediated or what definitive date is now scheduled for mediation. And then we'll come back on the motion to compel. Excuse me, and we're set on that date just for the temporary administration. We'll come back on the motion to compel and anything else filed. That date is on.
How much time you're on?
The next available setting.
That'll be, we can give it October 6th at 2 p.m.
All right, Mr. Knotson.
That's fine, Judge. And
Ms.
I'll confirm mess on that. Hopefully we can get everything resolved. Thank you, Judge.
Just one tangential and related matter, and Mr. Knotson is here as well. Pivoting to the estate of Vernet Karansa, Judge, it's not on the docket today. I'm one of the attorneys there. Mr. Knotson's the other attorney. Your Honor had required everyone to submit proposed orders by last Friday, and on the docket, it said that you would issue your ruling yesterday. And so we didn't have, that's what it said on the docket. So we didn't get a ruling. So I would just like for number one, I want to let the judge, let Your Honor know that at least on our side, on behalf of Maria Elena Montemayor, we did upload to case lines the Word version of our order that was filed, that includes some of the limited agreements that we had with Mr. Knotson for Your Honor to work off of in the event Your Honor was going to take some original drafting. So it's uploaded to case lines in Word. It was uploaded today. And I just wanted to let Your Honor know that, because it is important as to whatever is ruled on in the Vernet Karansa case is absolutely important for this case, because it determines what assets are in this case. So that, I believe, and I'm hoping Mr. Knotson will agree with me, that once we know what was actually settled and ruled upon and agreed upon in the Vernet Karansa estate, we'll determine what is left in the estate of Henry Karansa.
Mr. Knotson.
Yes, Judge, thank you. And thank you for considering this. I think the court ordered, and I did work. I got a call like 5 minutes till 5 on Friday when it was due. I did file our response directly quoting word by word and clarification by clarification by the court. I believe the initial order that was submitted was totally inconsistent. Not totally, majority inconsistent with what the court ruled. Then they submitted, he told me he submitted a new one yesterday, or if it was just submitted today. I submitted ours by the deadline. Mr. Flores and I agreed. He had to leave a little after like 5:20, says, let's talk Monday. Apparently he filed an advisory to the court, which he told me he was, that we were going to confer. I called, I believe after 5:30 yesterday, he wasn't there. I will call him as soon as I get done right now, unless Ms. Garcia wants to call me to confer. But my order was the only one that was filed on time. I believe it has the agreement where they did take out a lot of language that was totally inconsistent with the court's ruling. It does include a specific that the court listed as number 9, I think, a settlement agreement, release of all claims between the parties. We did that. He said he was going to redline mine on Friday, and I'm not sure if that's part of what they submitted with the court today, but he represented to me he would do that. And my client would just like to have a hearing. The court says, look, hopefully there can be an agreed judgment. I think we did make progress on Friday, talking like for 15 minutes, but then he had to leave. But I think if we have an entry of judgment hearing, it should be very simple. What's in dispute, and you make your ruling looking at the transcript. It's really that simple. But if you can give us maybe till Thursday to confer, hopefully we can have an agreed order. Or if not, my client would just like to have a hearing that should not take more than 10 minutes to go over maybe 3 points that differentiate, I think, off the top of my head, between their order and our order, and you can determine what's the appropriate version.
Your Honor, if I may respond.
No, Mr. Knudsen, Ms. Garcia, the court has made its decision and given you September 1st at 1 p.m. Date for the temporary administration. And the rest of the filings, the motion to compel, and the rest are set for October the 6th. I let one party go, and then I had to give equal time to the other on a case that isn't set for today. I wish you all the best. Thank you all.
Thank you, Judge.
Ms. Noriega.
Yes, Your Honor. Next is counsel in person, Guadalupe Canales, page 5/12.
This is Laredo Housing Authority versus Mireya Pintor, cause number 2026 CVD 1L2. Court marks Ms. Canales, present in person. Counsel, remind me your name, please. Mr. Miller, you're here on behalf of Laredo Housing Authority?
Yes, Your Honor, and I believe we can announce the agreement. Thank you so much.
Court marks Mr. Miller, present in person. Ms. Canales, present in person. Are you? Give me 1 second. Are you Mireya Pintor?
Yes.
Sí.
Court marks you present by video conference.
Esto por medio de videoconferencia.
Ms. Canales, Mr. Miller, what is the announcement?
Judge, we did have an opportunity to confer. I believe the parties have reached an agreement. Our intention here this afternoon is to announce that agreement on the record and then memorialize that.
Sí, señoría, hemos llegado a una, creo que las partes hemos podido llegar a un acuerdo y nuestra intención es para que se lea el acuerdo del día de hoy frente al juzgado.
And I'll try to keep it statement by statement, Judge.
Let me just see if you can get really close to the microphone so we have a good record. Go ahead.
Voy a tratar de darlo.
So Judge, the terms of the agreement that I believe that I have reached with Ms. Canales is the first point is to release the funds in the court registry that have been paid by Ms. Pintor to the Laredo Housing Authority.
El primer punto que tenemos es que se liberen los fondos que están en el registro del juzgado.
The second provision, Judge, is that Ms. Pintor is going to make a payment to the Laredo Housing Authority directly in the amount of $2,000.
Entonces la señora Pintor va a hacer un pago a la Housing Authority por la cantidad de $2,000.
The next provision, Judge, is on September 18th, Ms. Pintor would pay $1,299 to the Laredo Housing Authority.
Siguiente es que el septiembre 18 la señora Pintor va a pagar la cantidad de $1,299 directamente a Laredo Housing Authority.
And then the fourth provision, Your Honor, would be on October the 2nd. Ms. Pintor would deliver the final payment under this payment arrangement in the amount of $1,299.
Entonces que en octubre, el día 2 de octubre, la señora Pintor va a pagar, va a ser el pago final debido a este acuerdo de $1,299.
At that point, Judge, if all payments are forthcoming, my client will dismiss this matter with prejudice.
Si todos los pagos se cumplen como el acuerdo, mi cliente va a...
But in the instance or in the event that one or more of these payments are not forthcoming or are not received by the Laredo Housing Authority, we will ask the court to issue a judgment for possession and any remaining sums due and owing under the lease.
Is Canales?
That does reflect the agreement that we had.
Ms. Pintor, is this your agreement with the Laredo Housing Authority?
Sí.
Did you enter and have you entered into this agreement freely and voluntarily?
The microphone for interpreter is off.
Sí. Sí.
Did you
Inaudible
enter
for
into this?
interpreter.
¿Usted entró en este acuerdo voluntariamente?
Sí.
Yes.
And did you do so after conferring with your lawyer?
¿Y lo hizo después de que se comunicó con su abogada?
Sí.
Yes.
The court hereby adopts and approves this agreement. It's a binding and enforceable ruling of agreement.
El acuerdo es aceptado por el juzgado.
These are the orders of the court due to the court honor before.
August 31st at 12 noon by submission.
Las órdenes deben ser introducidas al juzgado antes de agosto 31.
And then we'll come back for entry. So you file those orders before August the 31st, but since there's some benchmarks that need to be met, I'm going to schedule this for entry of judgment after October the 2nd, at least a week or two after.
Do you want October 8th at 2 p.m. Fine, Your Honor?
Yes.
Yes, Your Honor.
So on that date, the Laredo Housing Authority will by that date, the Laredo Housing Authority will either file a motion to dismiss or request whatever other request they need to make.
Thank you very much.
Para la fecha de octubre, el Laredo Housing Authority puede hacer la solicitud que requiera o desistirse del caso o cualquier otra petición que tenga para la fecha de octubre 8 a las 2 p.m.
That concludes this matter today. Ms. Pintor, do you have any questions for the court?
Eso concluye el asunto por el día de hoy. Señora Pintor, ¿tiene alguna pregunta para el juzgado?
No.
No.
Anything else for the record, Ms. Canales?
No, Your Honor, that's all.
Mr. Miller?
Not at this time, Judge.
Good to see you all. Have a good day.
Actually,
tengan un buen día.
I apologize, Judge. One other matter, and that is just for convenience of all parties, including Ms. Pintor. Would we be able, to the extent we need to have an entry date and have any further hearing, can we agree to do that just via Zoom?
By agreement, it'll be authorized. Any objection?
No.
So ordered.
Thank you, Judge. I
Alright.
apologize. Thank you very much.
Have a great day, everyone.
You as well.
Next is Counsel Luis Landeros, page 10, number 25.
¿Ya me salgo?
This is Sara Villa versus Ruben Cabera Jr., cause number 2026 CVA 458C3. Good afternoon, Mr. Landeros.
Good afternoon, Your Honor. Great to see you.
Likewise, court martial present. You're participating by video conference. Sara Villa, Ruben Cabrera. Any parties present?
No, Your Honor. This is one of these cursed cases. I've been unable to find the defendant. Hired a process server that went to the last known address, was unable to find them. I went to the DMV headquarters in Corpus and pulled records, and there's no change in address according to records. Now it turns out I can't find my process server either to get me an affidavit of non-service. So I'm going to ask for a short extension to hire another process server and then file a motion for alternate service.
Right, so let's do this. This is the second one, so this would be number 3. Ms. Noriega, give us that calendar call in October.
October 8th at 2 p.m. I'm sorry, 9 a.m.
October 8 at 9 a.m. Now, if you need to file anything before Mr. Landeros, I'll review and sign off on it, to review it and sign off on it as required before that October the 8th setting.
Will do, Your Honor.
All right. Any other cases for Mr. Landeros?
That is all for today.
It's good to see you, counsel. Have a great
Great to
day.
see you, Your Honor. Have a great day.
Next, Council Adam Cardenas. I don't have him on my docket, Your Honor.
Mr. Cardenas, what page and case are you here on?
Your Honor, I'm here on behalf of Foundation Energy Services LLC versus Vision Oil and Gas LLC.
Page 13, number 30.
Foundation Energy Services LLC versus Vision Oil and Gas LLC, cause number 2026 CVI 859C3. Counsel, remind me what party you represent?
Foundation Energy Services, Your Honor.
All right, so noted. So Cardenas, the court marks you present. You're participating by video conference. Anybody here on behalf of Vision Oil and Gas? Counsel, what is the announcement?
Your Honor, this is a calendar call. I guess I just want to explain the status of the case. We had to file an amended petition. There was an issue with the Secretary of State. We found the appropriate registered agent, and we got him served on August 7th. So we're awaiting a response. He has sent a letter. We believe he will likely provide an answer soon, and we'll move forward with discovery on this, Your Honor. And if not, we'll proceed with the default.
Give us a calendar call in October.
October 8 at 9 a.m.
October the 8th at 9 a.m. Now, Mr. Cardenas, the purpose of our calendar calls primarily is so the court can enter into a pretrial guideline order, or if requested, we can hear anything else, special exceptions or special appearances or anything of the sort, default judgments. But the other way to forego the necessity of a calendar call is to enter into a pretrial guideline order. So if there's service on Vision Oil and Gas and there's some communication, you can just forego that hearing by filing a pretrial guideline order.
Duly noted, Your Honor. Thank you very much. I'm used to doing status conferences for defaults and have approached it the same way, I suppose. This one was a little weird because of the SOS issues. Thank you for your guidance, Your Honor.
Anything else on this case, Mr. Cardenas?
No, Your Honor, nothing further.
I wish you well. Have a good Tuesday.
Likewise. May I be excused?
Yes, sir.
Next, Counsel Nathan Chu, page 3, number 7, as an item.
The matter of Cristina Martinez Ortiz, cause number 2025 CIG 20L2. Court marks Mr. Chu present by video conference. Counsel, what is the announcement?
Good afternoon, Judge Nathan Chu present for Ms. Ortiz as ad litem. I have filed an application for appointment of a guardian, Your Honor. So just awaiting Your Honor to appoint a guardian.
Oh, I see.
That was my only function, is to determine that she's incapacitated and that she would need a guardian. And then from there, file for the court to appoint a guardian.
But you filed the application for the appointment of a guardian, not a guardian ad litem, but an actual guardian.
I'm already at the ad litem. Yeah, so I'm just
Right.
requesting the court to appoint a guardian.
We're here for a docket control call. I guess we need to set that application now for hearing. Give us an application hearing date.
That'll be October 8th at 9 a.m.
Any objection?
No objection, Judge.
All right, I'll call this case then. Any other cases for Mr. Chu?
Yes, page 4, number 8
Has been
has been called.
called. Yeah, they're set for October the 8th at 9.
That is all for counsel.
It's good to see you, Mr. Chu. Have a great
Good to
Tuesday.
see you, Webb. You too. Bye-bye.
Next case is for counsel Del Valle. I don't know what case you're here for.
Counsel del Valle, what case are you here for?
Good morning. I'm sorry, good afternoon. Do you have the number,
Madam?
Elsa Alicia Buitrón, Roberto Buitrón versus Oscar Joel Amador, Vicente Amador Ramirez, Elaim Hernandez, cause number 2025 CVM 1702. Court marks Ms. Del Valle, present and participating by video conference. Henry Falcon or any other persons. Anybody else present on this case?
Good afternoon, Your Honor. Henry Falcon on behalf of the plaintiffs.
Court marks you present and participating by video conference. Anybody else present? All right, counsel, what is the announcement?
We've
Judge,
settled this case, Judge. I'm sorry, Mr. Falcon.
no, go ahead, please.
We've settled, Judge, and I believe that this morning, probably late in the morning, the motion to dismiss for your honor's consideration was filed.
And we did provide, Your Honor, a notice of the settlement back in July with the court, along with the Rule 11, Judge.
Correct.
Court has received that request for dismissal. The court has signed that original order and is tendering the original to the clerk's office. This case is closed. Any other cases for Ms. Del Valle
No, Your Honor.
and for Mr. Falcon?
None, Your Honor.
Good to see you both. Have a great Tuesday.
Thank you, Your Honor. May we be excused?
Likewise.
Yes.
Thank you, Judge.
Next is Counsel Jeffrey Downing. I don't have him on this.
Mr. Downing, what page and case are you here for?
Judge, I'm here for American Express National Bank versus Juan Gonzalez.
Page 4, number 9.
American Express National Bank versus Juan Gonzalez III, aka Juan T. Gonzalez III, cause number 2025 CVF 94L2. Court marks Mr. Manning present by video conference. Any other person present on this case? Counsel, what is the announcement?
We're ready, Judge. We're asking for a default judgment be granted on this.
Go ahead.
Pardon me?
Go ahead.
We had to apply to the court for alternative service, and that was done on June 20th, Judge, by posting the service on the address that we have for Mr. Gonzalez. Still, no answer has been filed by the defendant, no communications from the defendant. We've just heard nothing from him, Judge. And so we're asking for the default judgment to be granted.
Clause number 2025 CVF 94L2. The court hereby finds that it has jurisdiction over this matter. The court takes judicial notice of the entire case file, including the original filing. The filing date, December the 5th, 2025. The court takes notice that defendant was heard with process in June of this year. The court finds in favor of the plaintiff and against defendant in the amount of $22,066.53 with the cost of the court. I guess the court should note on the record that although service was perfected, no answer has been filed and defendant isn't present. Default judgment is granted. Court has signed an order and tendering the original to the clerk's office.
Thank you, Judge. I appreciate that.
Closed. Anything else on this case, Mr. Downing?
No, sir. May I be excused?
Yes, sir. It's good to see you. Have a great Tuesday.
Likewise, Judge. Thank you. Bye-bye.
Your Honor, I believe we have called all the attorneys on person, just pending the uncalled and
Page 3, case 5, Maribel Flores versus Hyundai Motor America, Inc., cause number 2024 CBF 51L2. Attorneys Ginsburg or Garrett, are you present? It's the clerk's office. Since no one is present, has there been any filings?
Page 3, number.
Inaudible for the clerk.
Yeah.
Court has heard that there are no filings in that case. Give us one last entry of judgment.
Yes, Your Honor, that'll be October 6th at 2 p.m.
So ordered.
Sorry, I'm sorry.
Right, there's a notice of settlement, but we're still pending the judgment. Give us that entry of judgment date.
That's October 6th at 2 p.m.
So ordered. Page 5, case 11, the estate of Rogelio Solis Jr., cause number 2025 PB 769L2. There's an inventory on this case. Has an inventory been filed? Rebecca Marroquin or Leroy Solis, are you present? Court finds no persons are present, but there is a third motion for extension. For the reasons stated in the motion, the request is well taken and granted. Give us another inventory date.
And how much time is your requesting on that 90 days? I can give it the November 12th at 2 p.m.
Request is for 60 days.
2 days.
I'll give us late October, early November.
No, November 12th at 2 p.m.
So ordered. Page 6, case 15, Jasmine Hernandez versus Allstate Insurance Company, cause number 2026, CVF 32L2. Jason Palker, Nicholas Smith, or any persons present on this case? There's a motion to compel statutory mediation. The parties have and are going to mediation. We'll leave it for calendar call on September the 17th at 9.
Yes, sir.
Page 9, case 23, Cascade Capital LLC, assignee of Santander Consumer USA Inc. versus Miguel Hernandez, cause number 2019 CVI 1828C3. Any parties present on this case? Court finds no lawyers, no parties are present. There is a request to withdraw the application. It is well taken. It is signed. This case is closed. Page 12, case 28, Jose Luis Garcia versus Joel Diaz, DVN Motor Freight LLC, DBA Great Plains Processing, cause number 2026, CVF 923C3. Counsel Jason Palker or any parties. Anybody present on this case? Court finds no persons are present in person or by video conference. Is there a filing in this case?
There was a motion for continuance that was just granted and e-filed.
What is the next calendar call date?
October 8th, Your Honor.
Yes,
At,
at 9 a.m.
alrighty. Court will resume calling cases that are now contested. The first contested matter, yes.
I may interrupt. I believe there was a recall on Mr. Jose Luis Castillo.
What,
That is page 7, number 17.
the estate of Ortensia Ramirez, cause number 2026, PB4 5702. Mr. Castillo, are you present?
Yes, I am present, Your Honor.
And Felipe Ramirez IV, are you present?
Yes, I am, Your Honor.
Welcome to court, Mr. Ramirez. The court martial present by video conference from the office of your lawyer. Are you ready to proceed, Mr. Castillo?
Yes, he is.
All right, Mr. Ramirez, I'm going to ask that you raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
You may lower your hand, Mr. Castillo. Go ahead.
Yes, Your Honor. Will you please state your name for the record? Felipe Ramirez IV. Okay, and did Ortensia Ramirez die on or about May 24th, 2006 here in Laredo, Webb County, Texas? Yes. Was Ortensia Ramirez, she was 80 years old and residing at 2214 Chacon Street here in Laredo, Webb County, Texas at the time of her death? Yes. To the best of your knowledge, did she die without a will? Yes. Was there any children or adopted born to her? Yes. And there was only one child born to her, is that correct? Yes. And that is yourself, Felipe Ramirez IV? Correct. And you were born October 31st, 1986? Yes. Was she married at the time of her death? No. She was a widow, is that correct? Yes, she was. And is there a necessity for a temporary administration of her estate? Yes. And the sole purpose of the main asset or the reason for the necessity of the estate is to handle and finalize a personal injury claim that she had pending. Yes. And you're asking this court to grant a temporary administration and to grant you the powers to be able to resolve her personal injury claim on behalf of the estate. Yes. Okay. Have you ever been found incapacitated? No. Have you ever been convicted of a crime?
No.
And you're a resident of Webb County?
Yes.
And you lived in Webb County for how long?
39 years.
Okay. And is there any reason why you should not serve or be disqualified?
No.
And you're asking the court to appoint you temporary administrator of the estate?
Yes.
Okay. That's all I have, Your Honor. Judge, as to the bond, we're requesting the court send a cash or surety bond of at least $1,000. Judge, he's the only heir, and the only asset of the estate is just resolving this personal injury claim, Judge.
Mr. Ramirez, in the case of your mother, cause number 2026 PB 45702, the court hereby takes judicial notice of the entire case file. The court finds that it has jurisdiction. The court finds that unfortunately your mother passed away at the age of 80 on the 24th day of May 2026. The court finds that you are her sole surviving heir. No other children were born adopted by her. The court finds she was a widow at the time of her passing. The court finds that there is a necessity to administer her estate. The court finds that you are qualified and not disqualified from serving. The court hereby grants your request and grants this temporary administration with a $1,000 surety or cash bond. I have signed an order to that effect, and I'm tendering the original to the clerk's office. Anything else on this case, Mr. Castillo?
No, Your Honor, I do have the bond and the oath, and they will get signed and filed probably by tomorrow morning, Judge.
All right, Ms. Noriega.
Yes, Your Honor, the 180 days will expire February 15th. We do have a setting for February 2nd at 2 p.m. I don't know if they're going to file criminal law.
We'll set it for February 2nd so it doesn't fall through the cracks, but Mr. Castillo will file something before that. Mr. Ramirez, do you have any questions for the court?
No, Your Honor.
I wish you well, sir, and you have the court's condolences.
Thank you.
Thank you, Judge.
Mr. Castillo, it's always good to see you. Have a great Tuesday.
Likewise, Judge. Thank you.
We'll now commence with the contested matters. First contested matter on the court's docket is page 5, case 13, Rogelio Fabian Gonzalez Mercado versus Roella Jr., cause number 2026 CVD 4802. Court marks Mr. Romero present in person. Mr. Rogelio Fabian Gonzalez Mercado is also present in person. Mr. Romero, what is the announcement?
Your Honor, Mr. Vela is also present via Zoom.
Mr. Vela, are you Roella Jr.?
Yes, sir. Yes, Judge.
Welcome to court, Mr. Vela. The court marks you present by video conference. As you can see and hear from your device, your lawyer is present in person. Mr. Romero, what is the announcement?
Your Honor, I spoke to Mr. Gonzalez and advised him of the issue with the fact that he filed his claim against Mr. Vela Jr. individually instead of the company, but he wishes to go forward.
Well, so this is a claim that Mr. Gonzalez brought, correct?
Yes, Your Honor.
And ostensibly, he was a non-prevailing party at the Justice of the Peace Court, and he is now appealing?
No, it's the other way around, Your Honor. Mr. Vela is the defendant. The judgment was against him individually, even though there was evidence presented that the claim should have been made against the company. Therefore, we appealed.
Right. And so I guess to the court's point, because it's a trial de novo, Mr. Gonzalez continues to remain the plaintiff with the burden of proof at this trial de novo.
That's correct.
All right. Mr. Gonzalez, are you ready to go forward?
Yes, Your Honor.
All right. You may proceed. Will you be testifying?
I went to the court with Jose Salinas, and he granted me half of the amount I was originally asking because Roella Jr. doesn't have a contract that states that he was going to take illegal deductions out of my checks when it was a part-time job, and I was earning the minimum wage, and the last year that I was working for them, they raised me for $8 an hour. So I'm just here asking for the amount that he took from January 2025 to February 2026.
I guess I hadn't placed you under oath because I presumed that you were going to give an opening statement, but it sounds like you're testifying. So let me give you an oath now, Mr. Gonzalez. Would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
You may lower your hand. Mr. Gonzalez, is everything that you've told the court prior to this true and correct?
Yes, Your Honor.
Is there anything else you want to say or state or testify to on the record?
Mr. Romero informed me, he was very informative and professional about how I should sue Jebo North and not Roquevela, but it's a family business. And after Roquevela Sr. passed away, the only one that's left, it's Roella Jr. And even before that, he gave me his word that he was going to return me the money on cash on December 2025. Oh, no, yes. And then I asked him again on February 2026, and then that's when he fired me, and then he blocked any communication towards me. So that's when I took legal action towards him, because he's the one who authorized the illegal deductions out of the employees' paychecks. Only the employees that work the bar. So the issue here is when we're talking about beer, it doesn't matter if it's an aluminum can or glass can or kegs, the beer is gonna be always foamy. And I have pictures of how I have pictures how he was charging the employees, and how it was a 64-ounce pitcher of just foam, and he would charge only the employees who would serve the beer and not charge the managers who would serve the beer.
Is there anything else you want to tell the court on the record?
That's it, Your Honor.
Mr. Romero,
Your Honor,
anything on cross-examination?
yes, a couple of questions. Mr. Gonzalez, who employed you?
Back then it was a lady, two ladies, Christina Hogan and Belinda Hogan. They were sisters.
Okay, but what was the name of the company that employed you?
Jebo North.
Okay, and who, when you received your paycheck, what was the name of the employer on the paycheck?
Jebo North.
Jetbo North
Yes.
Inc.
Yes.
Okay. So then your employer and the person who paid you was Jetbo North Inc. Is that correct?
Yes.
Okay. And your lawsuit that you filed was against Roquevela Jr. Is that correct?
Correct.
Okay. That's all I have, Your Honor.
Do you have any other witnesses, Mr. Gonzalez?
She's not here. She's also trying to sue him, but he's not responding at the moment.
All right. With no other witnesses, that would be your case in chief. Mr. Romero, does Mr. Vela have any witnesses?
Oh, no, only Mr. Vela.
Only who?
Him, himself.
Are you calling him to testify?
Well, Your Honor, at this point, I would ask for directed verdict. Based on the testimony presented by Mr. Gonzalez himself, he stated that his employer and the owner of the business and who employed him and received and who paid him his checks was the company known as Jet Bowling Inc. And therefore the case is against Mr. Vela Jr. individually, and so it's incorrect. He's the wrong defendant, Your Honor.
Would you like to respond to that?
Yes. I've been since I started working there since 2022 all the way to 2025. His parents, which is Cookie Vela and Roque Vela Sr., they were my bosses. On January 2025, that's when Roque Vela Jr. took over the business, and that's when he started doing the illegal deductions. I was the only one who noticed because I was the only one who get the check on paper, and everybody else will get direct deposit. So I was the one who informed all the rest of the employees who only work the bar. So I just told them to be careful and make sure you're getting the right amount, because like again, it was a part-time job and he was the minimum wage.
Mr. Gonzalez and Mr. Vela, in this case, cause number 2026 CVD 4802, the court finds that it has jurisdiction by virtue of the claim being filed in Justice of the Peace Court. It becomes a trial de novo on appeal, and that's what the court has done here. The court finds that Mr. Gonzalez was employed by JetBall North and brought a claim against an individual, not against the business. So I hereby grant directed verdict. And Mr. Gonzalez, what this means is that you have sued the wrong person. But don't believe that that doesn't mean that I've even touched the merits. I have no idea. And you've also not presented any evidence as to what those deductions were, but I didn't even go that far because I'm granting directed verdict because you have, in fact, as a matter of law, sued the wrong person. Directed verdict is hereby granted. These are the orders of the court, and those orders are due to the court on or before
August 31st at 12 noon by submission.
Anything else to put on the record, Mr. Gonzalez?
He was Roella Jr. He was my boss from 2025 to 2026. I would only answer directly to him, and like I said, only him authorized the illegal deductions.
I understand. I mean, like any new information, I've already made a legal finding that you were employed by JetBall North Inc. Anything else? Anything new information or anything else to put on the record, Mr. Romero?
No, Your Honor.
Mr. Gonzalez, Mr. Romero, Mr. Vela, I wish you all very well. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day.
The second contested matter is the estate of Maria Guadalupe Lopez, cause number 2022 PB4109L2. Court marks Ms. Elisa Marsoto, present by video conference. Mr. Jose Luis Castillo, present by video conference. Mr. Jonathan Garcia Davalos, present in person. Mr. Canales, not present. Ms. Patricia Garcia was present in person. Ms. Maria Guadalupe Reyes was also present in person.
And Judge, if I may, Mr. Canales and Mr. Castillo are no longer involved in this case. Mr. Canales had one of the heirs that settled out, and Mr. Castillo was our attorney ad litem for the heirship application.
All right, understood. What is the announcement? Oh, and the court also marks Mr. Natalio Lopez and Agustin Lopez sons present by video conference. What is the announcement?
We would like to proceed, Your Honor, with a motion for new trial, asking for the court to consider the evidence that was not provided at the hearing in which the court decided to make a distribution of the estate.
All right, this is a motion for new trial. You are the movant, you bear the burden. What would you like to state, or what evidence would you like to present, or what would you like the court to know?
Well, Your Honor, yes, I would like to bring in my client to testify, Your Honor.
Your client being Maria Guadalupe de Reyes.
Yes, Your Honor.
Ms. de Reyes, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God? You may lower your hand and speak much louder and much closer to the microphone. This is your witness and client. Go ahead, Mr. Garcia Davalos.
Yes, Ms. Reyes, please state your full name for the record.
And Judge, can they get closer to the mic, please? Mr. Davalos?
Yeah. Yes, there you go.
Maria Guadalupe Lopez de Reyes.
Okay, just so that the court be aware, how you related to the decedent in this case?
She was my mother.
Okay. Now, just as a matter of background, what do you do for a living?
I'm retired. I'm a widow. And
what did you used to do before you
I did
retired?
home health most of my younger years, and I managed a restaurant for a couple of years.
Now, Ms. Reyes, you understand that there was a hearing in which the court made a final decision as to the distribution of the estate of your mother, is that correct?
Yes.
And this distribution that we're talking about, this estate, it involves based on the inventory that was provided on March 19, 2024. And if I may, Your Honor, I would like for the court to it's already been filed. It's Exhibit 6 on my case lines.
You're asking the court to prompt Exhibit 6?
Yes, Your Honor, and it's already as part of the file because it's a document that was filed. It's the inventory appraisement and list of claims of the estate that was filed by the applicant Patricia Garcia.
Into the case, so it's part of the case. file.
But I'm putting it as an exhibit, as exhibit 6.
Any objection, Ms. Soto?
1 second, Judge, let me pull it up on my case lens here. Is exhibit number 6?
Ms. Noriega, go ahead and prompt case center exhibit 6.
Your Honor, if I can state my objections for the record? It
Yes,
was
go ahead.
twofold. It's twofold. One, the question was that it was the agreement or read into the record or the proposal was based on that inventory, and that is not correct. That was not what this is misrepresenting what was actually presented to the court at the final hearing. And the second one, the inventory was filed, I believe today into case lanes. But I do note that it is what we filed in 2022.
Mr. Garcia was the inventory filed into case center less than 24 hours before?
This one?
Yes.
Yes, I believe I filed it. I don't know if it was yesterday or today.
Well, there's a big difference. If it's not 24 hours before, then it's excluded. But in any event, even if it's excluded, it's part of the case file, and the court can just take judicial notice of the case file.
Yes, Your Honor, the court can take judicial notice of the
Court
case
hereby
file.
takes judicial notice of its file. All right, go ahead.
And so, as to this exhibit 6, which is a filed and sworn to by the applicant Patricia Garcia. I'm gonna show you, Ms. Reyes, and I'm gonna show it to the state. Does it show the lots of the estate that were distributed on that day and that were to be distributed but to the heirs? Is that correct?
Yes.
And one is lot 18,
Yes,
and what was the value that was provided to the court?
$32,381.
And then I'm showing you lot 2.
Yes,
That's what was the value that was provided?
$110,977.
And then lot 1. What was the value
Yes.
provided?
$33,517.
Okay. Now, this is the estate that the applicant Patricia Garcia had to distribute and provide to all the heirs. Is that correct?
Yes.
Okay. Now, in terms of I'm showing you Exhibit 8, which is the judgment declaring heirship, which is something that was signed by the judge. I'm going to show you Exhibit 8, and in this.
Just know that when you are not in front of the microphone, you're off the record.
Yeah, and so if I may approach the witness, Your Honor, so I can show Exhibit A, which is the judgment declaring heirship that was signed and approved by the court.
You may.
Okay, Ms. Reyes, I'm showing you judgment declaring heirship. Do you recognize it?
Yes,
Okay, and in this declaring heirship, does it show all the heirs in this estate? All 10?
yes,
Does it show as well the percentages that were to provided to each of the heirs?
yes.
And what was the percentage that was to be provided to each of the heirs from the estate of your mother?
110.
Okay.
And Judge, I'm going to object because that's incorrect. Some of the heirs listed are receiving a more of a larger share.
The court will note the objection for the record, and I guess make a decision at the end versus I guess whether it's factual or legal in nature, Mr. Garcia.
Yes, well, I mean, just to clarify, to the minimum, at least to a minimum, your share is 1/10, is that correct?
Yes,
Okay.
And of all the heirs here, the only one that has a clear difference as to the shares is Jesus Manuel Lopez, is that correct?
Yes.
Now, we're contesting and we're asking for the court to reconsider the judgment, the decision that was made by the judge on April 7, 2026. Is that correct?
Yes.
Now, there is an official transcript of that hearing. Is that correct?
Yes.
Okay, now I'm gonna show you Exhibit 7. And this is the official transcript that has been transcribed and marked as official to what happened by a court reporter, Donna Gore, Your Honor.
And Judge, I am going to object because that was not made available to me until this morning. And when it was transcribed, I did not receive a notification if I wanted to order a copy.
Okay. Your Honor, if I may,
Response, yes, sir.
I did inform Ms. Soto as to this transcript that was available, and way talking about probably more than a week at a minimum, that this transcript was available and that she could get one, but she had to go and basically approach Ms. Gore, because I cannot provide a copy without her getting compensated for the transcript. That's my understanding.
So I guess there's two issues. Let me set aside any out of court conversations with court reporters. I don't think the lawyers are going to testify to that, but this is paper and this court doesn't do paper. So I guess the question is a transcript uploaded to Case Center?
Yes, it's uploaded to Case Center. It's a transcript with official.
So just ask Ms. Noriega, just ask the court staff to prompt the Case Center number.
I'm sorry, Ms. Noriega, can you please provide the Exhibit 7 for the court to
Court staff will prompt Case Center 7.
and can you please go to as you can see, Ms. Reyes, what is it that it says? I guess if you can read at the top, or you can give the heading. What is it that we have here, Ms. Reyes?
It's the trial court for the Maria Lopez.
What is the count number that we have?
Oh, it's the 2022 PD 4000 109
Okay.
L2.
And it says the date April 7, 2026.
Yes.
Okay, and is that the day when you came in on the hearing?
Yes.
Please go to the following, can you please go to page 2 for the appearances? And so we have here, as to present on that day was Ms. Soto, the attorney for the applicant Patricia Garcia present?
Yes.
Okay. Now, just going straight to the substance of this hearing, can you please go to page 11? I mean, page 10? Yes. Now, on page 10, if you can please go to, you see on line 1 on your left-hand side,
Yes.
and what does it say?
Lot 1, lot 2, and lot 18, Pueblo Nuevo to the subdivision.
Going to,
And make sure you're on the record.
Yes, John. Now go to line 15, please. Scroll down. The remaining portion of the. Now I'm gonna ask you that you read from line 15 to line 17. I mean to line 18, Ms. Reyes.
And that is the Webb County Appraisal District market value for lot number 1. What is the amount? Is the amount correct at 18,880? As you see it on that document? Yes.
Okay, now I'm gonna ask you to read the following page 11 at the top.
Ms. Soto?
No, I mean,
Oh, I'm
Maria,
sorry,
can you
I'm
please
sorry.
go to page 11? At the top. Now, can you read from line 3 all the way to line 6?
Can you scroll down, please, to the market value? And this is for lot number 2. And the value for market purposes is listed at 76,030. Is that correct? Yes, correct.
Now read from line 7 all the way to line 10.
Okay, can we prompt line number 18, please? Okay, and this is the lot 18, Ms. Garcia. Do you see that this is also a market value at 17,890? Yes, correct.
Okay. Now, Ms. Reyes, based on this, is it my understanding that this is Patricia Garcia giving the values of all 3 properties based on that hearing? Is that correct, Ms. Reyes? That she just gave amount for lot 1, lot 2, and lot 18?
Yes.
Yes. Now, those amounts, if you compare them to the inventory, which is on exhibit, which is on exhibit 6, Ms. Reyes. Which is on exhibit 6, Ms. Reyes. Those amounts are not similar to the amounts that you see here in the inventory that was filed. Is that correct?
No.
Okay. Now,
They're based on 2019 when my mother passed.
Ms. Garcia, just wait your turn,
Sorry.
please.
yeah, no, and so Ms. Reyes, you were able to review the order that was provided by the court, in which it was finalized based on that hearing. Is that correct?
Yes.
And to your understanding, is that you're receiving about $3,000 for lot 2, is that correct?
Yes.
And Patricia Garcia is getting the full property of lot 2, is that correct?
Yes.
But object, Judge, that's incorrect testimony from what was provided to the court on the final hearing and on the transcript.
Remind the court, is the transcript already part of the record or not?
Yes, Your Honor, if I will move to put into
So
evidence.
it isn't, so my question is it there right now? Because I can just take judicial notice and let the record speak for itself. If it isn't, then I have to make another ruling. So is the transcript already part of the record?
I'm moving that it be part of the record, Your Honor.
Any objection?
I do, Your Honor, it's not, well, you know what, I'll admit it, Judge, because I'll ask Mrs. Reyes some questions regarding that transcript, so I'll waive my objection. You can come in.
Case Center 7, I just want to confirm, it is Case Center 7, correct? Case Center 7, the transcript of the final hearing is admitted without objection.
Okay.
As movements 1. Thank you.
Now, Ms. Reyes, on that day, were you being represented by counsel?
No,
Okay. And on that day, you, based on the, because you were even able to read the transcript, were you able to respond as to whether this was the agreement that you had?
no, there was no agreement. There was no communication, no negotiating on this proposition that was laid out.
Okay, and were you given an opportunity to explain to the court as to your opinion as to regarding this distribution?
Yes, the judge did ask me, just trying to understand the whole proposition deal. I was blown away. And during
No
that,
objection, non-responsive, Your Honor.
Sustained. Re-ask and then answer the question,
Yes,
Mr.
sir.
Garcia.
And why is it that you were not able to provide your opinion as to this distribution, Ms. Reyes?
well, mainly, I was under new medication, and I did tell my sister that it affects what I was going through, and I got very nervous, and I just couldn't think properly. And all I could understand was reimbursements and money and costs. But I knew that the proposition was, like I say, there was no agreement with my sister, prior to
I'm going to object the narrative.
Sustained. Mr. Garcia.
And Ms. Reyes, what is it that showed that you were not in agreement to this distribution?
well, just looking closely later on, that the math just didn't come not even close to fairness. And not only that, is just what Patricia, in her own terms, put out the proposition with no consent.
And so is your understanding that Patricia Garcia, as the administrator of the estate, was that she was to be fair to all heirs, not to herself only?
Exactly.
Okay. And in your understanding, what is it that she was doing as she was being administrator of the estate?
As far as I understood, she wasn't honest with us to laying out.
I'm going to object to speculation, Judge.
This is her opinion, Your Honor, as to how she's functioning as the administrator of the estate, and she does have a duty to the heirs as well.
Overruled. You can respond and the court will make its own evaluation. Go ahead.
Go ahead.
Yeah, well, like I say, we later on found out that she wasn't honest, she wasn't sincere with just the whole value of the property, the measurements or anything. Towards the end, we found out that it was 3 lots, and we just believed totally blindly on her that it was just the ranch. That's what we understood, it was a ranch. So when she made the decision.
I'm going to object the narrative, Judge.
Sustained. Mr. Garcia.
So what was the other reason as well that based on your opinion as to her function as the administrator of the estate?
Well, I just feel that she just took upon herself to decide last minute that at her terms, that's what it's going to be, because she had the position of the administrator.
Okay. So were you able to be given this distribution that was provided to the court on that day? Were you given to you and to the other heirs an opportunity to review it? That distribution that was done on that day?
No.
You never received it from her attorney, Ms. Soto?
No, she said, I asked for the transcripts, and she said that she would get it to me. But then I tried coming here to the courthouse and to get that transcript, and it wasn't available. Not that it wasn't available, it was just hard for me to obtain it.
Okay. Um. And Your Honor, if I may also move into evidence, exhibit number 5, which is a survey of the lots. And this will benefit the court to see the general layout of the 3 lots that we're talking about.
Is this a case center exhibit?
Yes.
What case center number?
I believe this. I mean, I put it as number 5.
It's case line number 1, Judge.
There is a request to admit case center 1. Is there an objection?
I do, Your Honor, there's testimony as to who drafted that or where it's from.
Yes, if I may just simply lay out Ms. Reyes, how is it that you came across with that exhibit, the survey of the?
I went to the appraisal,
I guess it was prompted without the request and I took it off and now you're asking. So I just want to confirm, are you asking that case center 1 be prompted?
Yes, yeah.
Court staff will prompt.
Okay, do you recognize that document?
yes.
How is it that you came across this document?
I went into to the appraisal office, Webb County. And I obtained the paperwork there.
And this is because you were inquiring as to the 3 lots that belong to your mother? Or
Yes,
the estate of your mother?
that's when I found out that it was 3 lots and that it had value.
Okay, and would this assist the court to be able to make a better assessment as to what the estate is, what lots we're talking about?
Yes,
Okay, would you be able to point out, for instance, where the house is in what lot?
in lot 2.
Okay, and then in lot 1, what is in lot 1?
That's the corner. My brother Roberto Lopez, apparently he obtained that property.
Okay, and what about lot 18?
Lot 18 is where Patricia, at her terms, put us for Natalia, Agustin, me, Maria, and Sandra to be sold and distribute after the sale, but with all the reimbursements that Roberto is asking for.
Okay. So in your opinion, lot 2 is the one that has the most value?
Yes,
And why is it that it has the most value?
because there's a house there.
Okay. And who's keeping that lot?
Patricia has lived there. As far as I know, she moved out for a while, but then she comes back. But it was abandoned for a while.
Okay. So based on the distribution that was, the order that was made, Patricia Garcia will be the one getting that lot?
At her decision.
And Your Honor, I will be moving as well for this exhibit to be put into evidence. As it would assist the court as well to understand the estate.
Any objection to case center 1 being admitted, Ms. Soto?
None, Your Honor.
Case center 1 is admitted as movements 2.
And now I'll be asking for the court to consider exhibit number 1, which is the order approving the distribution signed by this court. And asking for the court the court has already taken judicial notice and so the court can display exhibit number 1. Okay. And if you can please go to page page 1 at the bottom. And Ms. Reyes, is this the first paragraph where it says Patricia Garcia to execute a deed for lot 2? to Patricia Garcia's grantee, is this the lot in which she's giving herself that property? Which is lot 2?
Yes,
Okay. And then immediately after that is that she's to pay you $3,000
yes,
as well as your other brothers or siblings?
yes.
Does it say anywhere in the order that you were in agreement with this exchange and that you wanted to be paid so that she could get that lot?
No. Was never mentioned, was never negotiated. She just threw out that number.
No, Objection non-responsive after no, Your Honor.
Sustained.
Okay, so you didn't find that type of transactional?
No, we
in
didn't
the-
sign nothing. It was her decision.
And are you at this time asking for the court to reconsider to all this evidence that was not provided at the time when you were present at the hearing? And that would have allowed the court to make a more sound, a more educated or sound decision, information that was not provided to the court so that he'll be able to assess and be able to show that all heirs are being treated equally and fairly?
Yes, so
And what you're asking is for the court to what, to do what with the 3 properties?
sell everything and fairly distribute to all the heirs that are still present.
Okay, I'll pass the witness, John.
Court will hear cross-examination momentarily. We'll stand at ease for a few minutes. Court is back in session and we are on the record. This is the estate of Maria Guadalupe Lopez, cause number 2022 PB 4109L2. We're here on a motion for new trial. Movement has just testified, and Ms. Soto, the non-movement, was about to cross-examine. Ms. Soto, are you ready?
I am, Judge.
Right, Ms. Maria Guadalupe Reyes, please step forward once more. Ms. Reyes, you were previously placed under oath. You continue to remain under oath. Ms. Soto will now cross-examine, which means she'll ask you some questions. Ms. Soto, when you're ready, go ahead.
Yes, Judge. Ms. Reyes, you're fully literate in English, right?
Yeah, yes.
You read, speak, and understand English?
Pardon me?
You read, speak, and understand the English
Yes.
language?
Yes,
And you were present in person on April 7th, correct?
yes,
And your siblings were also asked or afforded the opportunity to show up in person, correct?
yes,
And only you, Mrs. Patricia Garcia, and Roberto Lopez were the ones that showed up.
my two brothers were in the Zoom chat, but they were cut off.
Because the court required in-person participation, correct? Do you remember that?
Yes,
Okay, and you came in person, right?
yes.
And you came in the capacity of an heir.
I came with what?
You came in the capacity of an heir, a beneficiary of your mother's estate.
Yes, yes,
You did not file an application to be the administrator, correct?
yes,
Yes or correct, right? You did not file an application to be named the administrator of your mother's estate.
no,
And when you were able to hear everything that was read into the record, correct?
yes,
And did you hear that we told the judge that we were not deciding? We came here to ask the court to give effect to that proposal that Ms. Garcia had. Do you remember that?
yes,
Okay. And you provided to the court a testimony that's in the transcript where you were asking about rental income, correct?
of what member? I can't understand.
You were asking about rental. The court asked if you had any objections and you mentioned the rents, correct?
Correct.
The rentals that your siblings were paying rent.
Oh, yeah, about the taxes,
right.
yeah. that
Yes,
they
and the rent,
really
correct.
lived there, and we were in agreement that they were paying the taxes.
Correct. Okay, so that you mentioned that. And then the court specifically asked you if you had an objection to the distribution and you answered no. Is that correct?
Yes,
Okay. The document that you showed the court that you got at the Webb County Appraisal District. Do you remember that? The one with lot 1, lot 2, and lot 18?
yes,
Do you
I
remember
saw
that
them, I
document?
saw them, but at that moment, like I say, I wasn't much paying attention because how I felt ill.
Well, I'm going to
And-
take a non-responsive, Judge.
Sustained.
Ms. Reyes, I'm asking if the document that your attorney introduced as exhibit number 2, which is the small map of showing lot 1, lot 2, and lot 18. Do you remember seeing that document today?
Yes,
Okay. And you're saying that you never knew that those properties were actually 3 different properties, correct?
I knew that yes, I knew before the April 7th hearing that they were 3 properties.
All right, so you always knew that, right?
Yes,
Okay. And each one of them has its own tax ID for tax purposes.
yes,
Okay. And you were present at the mediations, correct, Miss?
yes.
What in the room that you were in, was it Natalia or Agustin that was with you?
Agustin,
Okay. And Mr. Romero, remember Mr. Romero, the mediator?
yes,
And he went back and forth because we were trying to reach an agreement, correct?
yes.
But no, like you said, there was no agreement
No, there was no agreement, no,
at the mediation, right?
yes.
But then we had the final hearing because we had no agreement.
Yes,
That, I'm gonna object to non-responsive after yes, Judge.
Sustained.
And you also heard Ms. Garcia mention that she was going to be waiving her administrator fees, correct? On April 7th. She wasn't gonna ask the court to pay her anything for being the administrator.
yes,
Did you hear that? Okay. And did you hear that we were requesting that the court allow the reimbursement to Roberto for attorney's fees and to Mr. Romero for doing the mediation because two of the grouped parties did not pay him? Correct? Do you remember that?
yes.
Okay. And what have you, the documents that you have, that you've introduced, you had all of those on April 7th, correct?
The documents that I have now,
Yeah, the survey with the lot 1, lot 2, and lot 18, you have those. That's public record.
I obtained them on my own because I needed to know, to have answers of how much was the shares worth, and
And you easily got them from the webcat, correct?
yes,
Because they're public record. They were denied to you.
yes.
Okay. I'll pass the witness, Judge.
Anything on redirect, Mr. Garcia?
Just to clarify, Mr. Reyes, you heard from opposing counsel asking you whether you had all the documents that have been introduced. This is not including the transcript of what happened on that day, correct?
Yes,
And this is not including even the inventory. Were you aware that there was an inventory with all the lots and the prices of the value to it?
no,
Or you provided a copy of that inventory by your sister?
no, none at all. In fact, I would ask her what was the value of my share and the whole ranch, and she couldn't give me numbers.
But objection unresponsive after no, Judge.
Sustained.
So the inventory was not provided to you?
No,
Even the declaration of ownership, did you even get a chance
No.
to look at that declaration of ownership?
no,
I pass it over to you.
Anything on recross?
I don't have anything on request, Judge.
Do you have any other witnesses, Mr. Garcia Davalos?
Yes, I would like to call the Mr. Lopez, they're on Zoom. The court gives me permission just to ask briefly questions.
Which believe Mr. Natalio and Agustin, which Mr. Lopez are you calling?
With the first one with Natalio Lopez.
Mr. Natalio Lopez, you're being called to testify. I'm gonna ask you to raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes,
You may lower your hand. Mr. Garcia Davalos, go ahead.
Mr. Lopez, just to clarify, how are you related to the student?
I am the one of the siblings, brother and sister.
Okay, and to let the court know, you understand that there was a distribution of the estate of your mother, is that correct?
Yes,
Okay. And you understand that we're talking about 3 lots, is that correct?
yes,
Okay, are you asking this court to sell the 3 lots and to distribute equally and fairly among all the heirs the profits from the sale of those 3 lots?
yes,
Okay. And so you're not in agreement with the distribution that your sister Patricia Garcia provided to the court as a distribution, is that correct?
yes, it's correct. No,
Okay, I'll pass the witness.
Anything on cross-examination?
Just one question, well, some questions, Judge. Mr. Natalio Lopez, you did not come into court on April 7th to give the court your position on the matter, correct?
what day was that?
April 7th, you were not present here in the courtroom on April 7th.
April 7th? No,
And you didn't file anything with the court.
no.
And
tried to get in Zoom that we're doing now, but it was cut off.
Okay, I'm gonna object to non-responsive after no, Judge.
And
And Mr. Natalio Lopez, you did not ask the court to name you the administrator in this case, correct?
No.
That's all I have, Judge, for Mr. Natalio Lopez.
anything on redirect?
Mr. Lopez, where do you reside?
Uh,
Where do you
can you
live?
repeat that? Oh, Milwaukee, Wisconsin, sir.
Are you in Wisconsin right now?
Yes, I am.
Okay. Were you able to come to the court last time we had a hearing?
I can't remember the date, but it was like a month ago or something like that. I flew down there.
Okay. What do you do for a living?
I'm a contractor.
And is it easy for you to come to Laredo, Texas?
Yes, it is.
You can come and go as you please to Laredo?
Oh, no, I can't. Oh, sorry about that.
Okay. And Mr. Lopez, you heard from the attorney asking you that you did not ask to be the administrator of the estate, is that correct?
Yes,
Okay, and your understanding is that Patricia Garcia, your sister, is the administrator of the estate, is that correct?
yes,
And your understanding is that Patricia Garcia, her fiduciary duty is to be fair, that her responsibility is to be fair to all the heirs and to treat everyone equally, is that correct?
I object to leading, Judge.
Sustained.
What is it that you think that Patricia Garcia should do as the administrator in distributing the estate to all the heirs?
well, to begin with, I mean, be fair with everybody, man, be fair with, whatever lands there, because we're a couple of siblings, and, just be fair,
Okay, pass it with me now.
That was redirect. Any other questions, Ms. Soto?
No, Your Honor.
Do you have any other witnesses, Mr. Garcia Davalos?
Yes, the sibling that is next to Mr. Natalio Lopez.
Will there be any new evidence or testimony?
Just 3 questions.
And I think it's Agustin that we're
Yes,
testifying now, right?
Yes, Agustin Lopez.
All right, for new information, evidence, or testimony, the court will allow it to Mr. Agustin Lopez. Would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Louder?
Yes.
You may lower your hand. I need you to speak as loud as possible so that we can hear you. Mr. Garcia Davalos, go ahead.
Okay.
Mr. Can you hear me?
I use some I have hearing aids. Sometimes they don't pick up what it is, but yeah, I'm gonna wear this to see if I can hear better.
Mr. Garcia Davalos, when you're ready.
Can you hear me, Mr. Lopez? Can you hear me? No, that's fine. I guess I'll go ahead and
So I think
Yeah.
these were some of the issues that the court wanted to avoid by
Yeah,
having
no, and
virtual hearings.
I'll go ahead and pass. Mr. Lopez, can you hear me?
Yes, I can hear you now.
Go ahead.
Okay. You heard the question that I made to your brother, is that correct?
No.
Did you hear the questions I made to your
I
brother?
think somebody's talking to him in the background, Judge. I heard somebody talking.
Mr. Agustin Lopez, who is in the room with you?
¿Cómo?
De que entra en el cuarto, el mollito.
Oh, only me and my brother.
Who else is with you?
Yes, me and my brother.
Who else is in the room?
Only me and my brother.
Mr. Garcia Davalos, go ahead.
Did you hear the questions I made to your brother?
That's fine, Your Honor. I'm gonna go ahead and pass the whatever.
Any questions for this witness, Ms. Soto?
No, Your Honor.
Any other witnesses, Mr. Garcia Davalos?
No, Your Honor.
All right, that would be your case in chief. Do you have any witnesses, Ms. Soto?
I wouldn't have any witnesses, Judge. I just have argument.
All right, then, so ostensibly this is closing, so you still have the burden, Mr. Garcia Davalos, so close with particular emphasis on what your client requests from the court and what evidence and testimony supports the position, particularly what elements necessary for the court to grant a motion for new trial have been met. Go ahead.
Yes, Your Honor, in a motion for new trial, I understand that the court has to be provided with evidence, especially evidence that had not been yet available on the day that the court rendered the judgment. On that day, Your Honor, as the court can see based on the transcript that I provided, the court was not able to get the benefit as this is a dependent administration, and as a dependent administration, the court is to get all the information so that the court can make a sound decision, and educated as well informed. And so in this case, Your Honor, based on the transcript, we can see that Patricia Garcia provided information values of 3 properties, the 3 lots that encompasses the whole estate, of values that are substantially less than of the values that were provided to the court in the inventory and that were actually granted as value of the estate, of the whole estate. And so there's a huge discrepancy in terms of the values. There's a huge difference between them. And also in terms of the value of especially lot 2, which is the one that has the house. And that one, there was a short difference. There was a drastic difference of about $30,000 between the lot 2 value they provided to the court in the inventory to the value that was provided to the court on that day of the hearing, which was from a Webb appraisal district. So, and that in itself, that value is amount that would have taken care of the amounts that they were talking about regarding reimbursement to the brother, or paying Patricia Garcia for her role as the administrator, also paying the mediator, Mr. Romero. That's just one. The other 2 laws, there's also discrepancy between the values. And so the reason why it is important is because at the end of the day, the fiduciary duty of the administrator is to do fair dealing, no self-dealing. And this on its face is more than clear that there was a self-dealing going on. She took it upon herself to keep the property that has the house. That obviously has all the amenities of a place where you can live in. And she decided to, in turn, give $3,000 to the other heirs. And so that is not a fair dealing. That is just clearly self-dealing, Your Honor. And I may go to the court as to case in Humane Society 531 Southwest 2nd, which was the executor. And that is clear that a personal representative must administer estate solely in interest of estate and distributees, not allow her personal interests to conflict with her duty, and not exploit fiduciary relationship for personal benefit. And that's exactly what we saw happen here on that day. We saw that Patricia Garcia decided to get rid of the other 2 properties that are empty lots, keep the property that has the house for herself, which is obviously conflicting with herself because this is a place where she lived. So obviously, not only is she getting some a better, a higher economic interest, but she also has sentimental value because she resided there throughout the time. And so the other heirs were letting her, okay, fine, as long as you continue paying the taxes and so forth. But when it comes to her putting on that hat of being the personal representative, the administrator of the estate, this is when she should have been, showing all the cards and saying, okay, these are the values of the lots. we're gonna have to sell. And we're just gonna give each other our fair share. And that's not what happened. And as the court is aware, not having the benefit of counsel is a huge disadvantage to a lot of people. And it was a huge disadvantage to Ms. Reyes and to the other heirs who were here present via Zoom. It's the whole purpose of why we're coming here for a new trial, so that the court can see that evidence that should have been provided to the court, and just simply being honest to the court and saying, Your Honor, this is the value that we have, that we filed the inventory. I know that we are now saying other values. What is it that the court thinks is that is a fair decision? We also heard testimony from Ms. Reyes telling the court that I did not get this proposition. It was done on that day. So to a certain extent, she was blindsided. She did not know what was going on. She just simply went ahead and said yes. And she sort of protested. She gave some sort of showing opposition. And in order to be fair, and also so that it can be avoiding this type of conflicting opinions about what to do with the estate, the only best and fair way is to just go ahead and sell the properties, whatever values, whatever profits can be done, that will be to take care of all the debts, any outstanding debts, and all the heirs walk off with a share, as the way it was ruled on in the declaration of heirship, and as the way she somehow decided to, obviously flip-flopped once she saw that she thought she was going to be able to get that benefit, but she did provide a fair value of the property. And then she shortchanged everyone on that day without giving the court the benefit of seeing those discrepancies. Had the court had that benefit, it is more than evident that the court would have taken all the precautions that would have to be taken in letting the other heirs know, hey, you're about to lose this amount of your interest. Because at the end of the day, we go back to it. What happened is that when there was a declaration of heirship, is that she and all the heirs got an interest in those lots. And so on that day, she on her own decided to divest those interests, keep the lot that she wanted to keep, that had the most value, and then get rid of the other lot. So what I'm asking for the court is to consider the evidence that has been provided to make the decision of selling all three properties as the way that I provided as well, not only this motion for new trial, but also the application to sell all three properties. It's also on file for the court to consider, and to just go ahead and sell the three properties, pay any debts, outstanding debts, and just give each other their fair share of the profits.
Same thoughts to you, Ms. Soto. You're able to close, keeping in mind what the legal standard is for a motion for new trial, and I guess in reverse, what has and hasn't been shown. Go ahead.
Right. So, Judge, the legal standard in order to have a motion for a new trial granted is you have to bring newly discovered evidence, a factual insufficiency on the record, or a legal ground. The only legal ground asserted in the motion for a new trial was that these properties were not subject to partition and therefore had to be sold. And the other legal ground was that it was not a fair distribution. I would tell the court there's been no evidence here today that's newly discovered. The documents that were presented were all public record, and they were presented to the court. The court saw that these were three different properties with individual property tax IDs on that date in question. They're easily divided. It's not one big property. It's three different lots. The court had heard from other witnesses before. April 7th, the court asked everybody to be present in person. Only 3 people showed up. And of the people that showed up, everybody said they were in agreement to the record. And 2 was read into the record. There was comments and the transcript was already part of the record, Judge. The transcript will show you. My client waived reimbursement of property taxes, waived her administrator's fee, and so did Mr. Roberto Lopez. The siblings had already disposed of one additional property. That was also put into the record. And one other heir had given her share to Mr. Roberto Lopez. So he had a larger share than the remaining heirs that were put into the record. So, Judge, there has been no information provided to the court that's newly discovered. There's nothing on the record that shows Ms. Reyes did not understand what was happening. There was no mention of any objection to any of the distribution requests as read into the record. And it wasn't just a reading into the record. It was an explanation of the payments, what was being waived, and values for each property. We don't think that there's any ground that was mentioned on the motion for a new trial that would merit a new trial. No legal ground was asserted and proved by Mrs. Reyes' testimony or Mr. Natalio Lopez's testimony to show the court that something was left out for the court's consideration. This was a dependent administration. My client didn't choose. She presented the offers. The offer came at the final hearing, and the court approved it after hearing that nobody present was objecting. And I will, just to clarify for the court, Your Honor, I'm not going to list what would happen at the mediation, but we did go to a mediation and we did try to settle. So for Mrs. Reyes to imply that I did not provide information, there were millions of offers going back and forth. We never came to an agreement because there were so many heirs. And that's why I kept representing to the court at every single hearing. There's too many, we need to have a final hearing because we're never gonna agree. We came with an offer, nobody objected, and today there's been no evidence presented that's newly discovered evidence or any legal ground asserted that would grant a new trial for the court.
Anything else from any side? All right, Ms. Garcia, Ms. Reyes, I'm going to make a decision just as a matter of law in cause number 2022 PB4 10902. But I guess for each of your benefit, for whatever it's worth, let me just tell you that these cases are always difficult. They're difficult for the parties, and I want to say they're difficult for the court, but the court does get to see many families at the end of someone's life torn apart by the distribution of a loved one's belongings and properties. And that's, I guess, what makes it difficult for the parties. And I guess by extension, the lawyers also get weighed down, and then the court gets to hear all of these things. That's separate from the decision. And the decision actually is pretty straightforward. I'm going to make a decision as a matter of law, but you need to know and understand that I make no judgment as to the values of your person or your character. The only thing that I'm doing is I'm taking the facts of your case and applying the black and white letter of the law and giving you a decision without actually rendering any values as to each of you as persons and as loved ones of your beloved mother in this situation. But let me just take judicial notice of the entire case file, and I think that was what was requested by the court. One of the things that I note is that this case was filed in December of 2022, and it took many hearings to get to a final decision, many mediations and service and notices and parties that were being served, because this is not a rather large estate, but a rather large family, I guess. And it wasn't until April that you all finally crossed the finish line. But what was announced to the court was announced as an agreement. So remember that the legal standard for a motion for new trial, as told to the court by both of the lawyers, is whether any evidence has been newly discovered but not available to the parties. And that wasn't what was testified to here. What was testified to here was that the evidence and information was just not available to the court. So it's a misapplication of the standard, because the evidence that was presented here was in fact available to the parties, and the court, the only thing that the court did was approve the agreement as stated by the parties. That's all the court did. Now, whether you all, did homework and research and verifications in that span of 2 or 3 years, that's on you all, not on the court. So the court approved the decision. So the court finds that the legal standard, I guess in this case, just has not been met. The motion for new trial is respectfully denied. These are the orders of the court, and the orders are due to the court on or before
August 31st.
Ms. Garcia, do you have any questions for the court? Ms. Reyes, do you have any questions?
Into the microphone, please.
You may say whatever you want.
Prior to when the mediator, the hearing that we had, that we couldn't come to an agreement. Three times we had hearings, and the 3 times we had come to an agreement in communication with the siblings. Until every meeting, Patricia was the one that didn't disagree. And so I was asked one of the times, I don't know if it was after the mediator, that if I had anything to say. And I did mention, how long is it always going to proceed if it's Patricia that just disagrees with us? So, I mean, I'm just saying she's been the one that has prolonged all these years. And honestly, to get what she wanted.
I understand, and I've heard the request, and
Yes.
believe me, I'm not saying that, I'm not making any other comments or value judgments on any person or any situation or any circumstance, other than to say this is exactly what the law says the outcome should be, without saying somebody, got it right or wrong. That's exactly what happens in this type of situations. Ms. Garcia, Ms. Reyes, and Mr. Lopez, I wish you all very well. More importantly, I wish you and your family peace. Have a good day.
Thank you, Judge.
Sure. That leaves one case pending before the court, page 6, case 14, Martiniano Ruiz versus Jesus Cadena, cause number 2026 CVD 62L2. Court marks Mr. Freeman present in person, Mr. Ruiz present in person. For the record, this is cause number 2026 CVD 62L2. Jesus Cadena, are you present? Court finds Mr. Cadena not present. Mr. Freeman, are you ready to proceed?
Yes, Your Honor. I represent Mr. Martiniano Ruiz, and this is an eviction suit.
Will you be calling Mr. Ruiz to testify?
Yes, sir.
Mr. Ruiz, I'm going to ask that you raise your right hand, please. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I swear.
You may lower your hand, Mr. Friedman. You may proceed.
Can you please state your name for the record?
Martiliano Ruiz.
And did you rent a piece of property to Jesus Cadena at 4220 Marcella Avenue?
Yes.
You rented a room out of that property, is that correct?
Yes.
And he quit paying you rent back in January of this year, is that correct?
Yes.
That was the last time he's paid your rent, is January.
Yes.
After that, you hired me as your attorney to send him a letter to terminate the lease and remove his possessions from the property. Okay.
Yes.
So on May the 7th, I sent him a letter terminating the lease and asking him to leave the premises by June the 8th of 2026. Is that correct?
Yes.
And after June the 8th came, he had not removed himself, and we sent him another eviction letter on June the 12th and asking him to leave by June the 15th. Is that correct?
Correct.
And on June 15th, we discovered he had not removed himself, so we filed a petition for forcible detainer in the Justice Court of Precinct 1, Place 1 in Laredo on June the 24th of this year. Is that correct?
Correct.
And at that hearing, Mr. Cadena did appear of record, and we had a hearing with the JP court. Is that correct?
Correct.
And in that hearing, the JP granted you possession of the property and asked Mr. Cadena to remove his possessions. Is that correct?
Correct.
And after that, Mr. Cadena filed an appeal to this court today, and that's what we're here for today. Is that correct?
Correct.
And what you're asking this court to do today is to give you possession of your property and have Mr. Cadena evicted from the property.
Correct.
Your Honor, I have no further questions.
Any other witnesses?
That's it, Your Honor.
Closing?
We ask the court to grant an order of eviction of Mr. Cadena and give possession of the property back to Mr. Ruiz. And I do know that the JP court has made it a condition of appeal that Mr. Cadena pay rent into the registry of the court. He's only paid 1 month's rent. He's not failed to do that. We'd like to repossess that rent that has been paid in that courtroom.
All right, anything else?
Just an eviction, Your Honor, please.
Mr. Ruiz, in your case, cause number 2026 CVD 62L2, the court finds that it has jurisdiction over this matter, meaning this is the proper court form and venue to consider granting this eviction. The court takes judicial notice of the entire case file and has now had the benefit of your testimony. The court finds that you are the landlord of this piece of property in Webb County on Marcela. The court finds that the occupant, Jesus Cadena, is your tenant. The court finds that he has not paid rent since January of 2026. The court finds that he is in default. The court finds that you have the superior right of possession. The court finds that you have presented all of the evidence and testimony necessary to grant your request. The court hereby grants your request, grants the eviction, and all funds in the registry of the court. The court grants you judgment in your favor is hereby granted. These are the orders of the court, and the orders are due honor before
August 31st, Your Honor.
All right, the court has granted your request. Mr. Ruiz, do you have any questions for the court?
No.
No. Anything else on this case, Mr. Freeman?
I'll submit an order, Your Honor, and as soon as we can get it processed, we'll do it.
Thank you, Mr. Friedman. Mr. Ruiz, we never know how long our contested matters are going to take. It's 5:13. You've been here since at least 2. The court thanks everyone for their patience. All right.
Thank you, Your Honor.
Wish you
Good to
all
see
a
you again.
good day. Good to see you, Mr. Freeman.
Been a while.
Thank you. Ms. Rodriguez, have all cases been called on today's docket? This now concludes this docket held in person and by video conference at Webb County Court at Law 2 for Tuesday, August 18, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court, like the clerk's office, our probate court investigator, and the sheriff's office. Thank you all. I wish you all a good day.